How's it going, Tom? Your identity there. Thank you. This is at the webcam. Nice to hear the nice music with.
Oh yeah. Plus, I'm testing the webcast real quick.
Okay.
Has joined the conference. Joined the conference.
Who just joined the line? By telephone?
Hello? Who have we got on, before we start, this is Steve Bundy. Who have we got online? We've got David, right, and Brandon in Laguna Beach. And then again, we have
Has left the conference.
Bridget, do we have are you still on the line?
Yes, Center for Public Interest Law in San Diego.
Great. And Brian Shear, are you still on the line?
Yes, I am here.
Great. Did I get your name right, Brian?
Yep, that's it.
Good. Okay. What we're going to do is call the roll.
Hey there. Just wanted to jump in. I'm Sejal Singh from the People's Charity Project. We are partners with Brian on, and we're calling in to support your very exciting resolution about non-compete agreements.
Great. Well, can you say your name again just for me? Because I didn't quite get it.
Sure.
Go ahead.
It's Sejal, Sejal Singh. Sejal Singh.
Sejal Singh. Thank you, Sejal. Okay.
No, thank you. We're happy to be here.
Okay. So our first step, we're going to call the roll, and then we're going to take public comment before we move on to our other administrative business. And I have a word to say about the public comment process once we get past the roll. So, Mimi, can you call the roll, please?
Sure. Stephen Bundy?
Here.
Ken Bacon? Sarah Vanola?
Here.
Kendra Vesner?
Here.
David Carr?
Here.
Justin Fields?
Here.
Toby Inlander?
Here.
Adam Koss?
Here.
Brandon Kruger?
Jessica Ramon.
Here.
Amber Lee?
Has joined the conference.
Here. Dina Roche?
Here.
Marsha Whitney? Thank you. Someone else just joined the line, by the way.
Okay, so what we're going to do now is take public comment from those of you who are online who want to speak. We are not going to reach the actual topic of what I understand to be your public comment, which is the improper contract provisions, until later in the day. We don't know exactly when yet, although we're estimating sometime around midday. What we're going to practice is to take public comment at the very beginning. Do you have an estimate about how long you want to speak for?
Each of us, you mean, or?
About 5. We're thinking 5 minutes or so per person. Does that sound reasonable?
Yes, that's more than enough for me anyway.
Great.
More than enough here as well.
Okay, terrific.
And me as well.
Great. Well, so we'll look forward then to why don't we start with whichever of you wants to start, and if you could identify yourself again for the record so that we can write down and be aware of whose comments we're actually listening to.
Why don't you call somebody? Ask.
Okay. Well, I'll just do it. Bridget, do you want to start?
Sure. Sorry. Sure, this is Bridget Grammy at the Center for Public Interest Law, and our center was, if you recall, back in the summer, in conjunction with some others, requested that that you look into this issue of the contract provisions. And I just wanted to thank the committee and for Mr. Carr for taking our public comments into consideration from the last meeting or two and coming back with the revised memo, which we really appreciate. And as far as my comments, I'll just limit it to, I really do encourage the committee to vote to take this up and write a formal opinion. These issues about non-competes and specific, illegal provisions and contracts, I think, are really important to the public protection mission of the bar, and something that is gaining, national attention. I just think it's something that would be very important for this committee to take up. So I know other people may have some more substantive comments about it, but I just wanted to give my overall support for the committee moving forward with an opinion, and to, again, thank everybody for their work on this.
Thank you. Brian or Sejal, do you have something to say?
Sure, I'll be brief. This is Brian Shear from Justice Catalyst Law. We've been working with Bridget on this matter, and I just wanted to applaud the COPRAC for considering the ethics opinion. We think it's really important, as demonstrated by the few of us that have joined, and I believe if you opened it for public comment, you would likely see substantial public interest. We've looked at the outline of the draft opinion, and I had one specific suggestion for consideration of the committee, which was the duty to withdraw, and I think it's number 7 on the outline. It states that a lawyer may withdraw if a client wishes to use an illegal contract, but it doesn't say they must. And it's our thought that if a client forces a lawyer to engage in an unethical act under Rule 1.16, that would meet the standard for having a duty to withdraw. And I recognize that this is a pretty big shift, even though it's not a minor suggestion. And so I think we would just hope that the issue be sort of open for comment, and that the committee get the full opinions of the commenters that will likely be submitting comments before landing on a definitive position on that specific issue. And that's all. I think we were really excited to see that you all are taking this very seriously, and I applaud you all for the work you've done already.
Thank you very much.
Thank you.
And Sejal, did you want to say something as well?
Sure. I'm happy to second everything that's been said. We applaud the resolution. We are extremely excited that it's being considered. The People's Parity Project is a group of law students organizing around workers' rights issues across the nation, and we do have several affiliates in California schools. I think some of them are very interested in this issue and have, raised concerns with us that, were they to they know that one day in the near future, bar willing, we will be attorneys, and they want to make sure that they know and have guidance about what they should do if they are confronted with a client who wants to write in one of these unenforceable non-compete agreements. They want to make sure that they know how to act in a situation like that.
Has joined the conference.
So I think we had someone else jump on, but I do think that this is a concern that's shared widely by both students and attorneys, and we applaud the resolution.
Okay, thank you. Is that it, or is there more? That's it. Is there anyone else who wants to publicly comment, who's on the line who hasn't already done so? Great. Okay, so with that, we will move on to our ordinary order of business. For those of you who are interested in the substantive discussion of the issue, as I said, we hope to reach it around midday, although our progress isn't mechanical or clockwork. So you might want to dial back in either before or after lunch and check and see how we're doing if you want to hear that discussion.
That sounds great.
Okay.
Thank you so much.
Right. Okay, now we can move back to the order of business. The next step is, I think, to review the report of our last meeting.
Has left the conference.
Oh, announcements, Andrew.
Jane
Announcements? Sorry.
Has left the conference.
Andrew, do we have any announcements?
Yes. Sorry, I was letting people depart the phone line. Okay, so I have a handful of things to report.
Cellular.
Has left the conference.
With respect to the work of the committee's ethics opinions, your opinion 16-0002 concerning data breaches is still up for public comment. As a reminder, it has a deadline of March the 30th. And your opinion 17-0001 concerning advising a cannabis business, public comment period just concluded on Monday, the 24th. We received 2 comments, and they're in your materials, and when we get to that agenda item, I'm sure we'll discuss those comments. The rule amendments that you recommended be made following study of Assembly Bill 1987 were presented to the board at their January 24th meeting. The board approved the rules as you recommended them for revision, and professional competence staff, along with our Office of General Counsel, has been drafting a rule filing petition. It's nearly complete, and hopefully we'll be able to send that up to the court sometime.
You're talking about the
And we'll see what they have to say about those recommendations. Also, at the board's January 24th meeting, they approved the ethical obligations when departing a law firm. 13-0003 is now formally published as opinion 2020-201. And on Monday, the 24th, in this very room, ADLS had their last regularly scheduled meeting. That's the Access Through Innovation and Legal Services Task Force. And they have voted out 7 recommendations, which are going to the board on March the 12th. That meeting is also here in San Francisco, if you're interested to follow via webcast or in person. And the 7 recommendations are the following. Recommendation number 1 is to recommend to the board that they issue for public comment an amended rule of professional conduct 5.4 to expand the existing exception for fee-sharing arrangements with a nonprofit organization, as well as a statement to continue other possible revisions to the rule. And so what that means is, if you recall, under 5.4A5 today, a court awarded fee split may be shared with a nonprofit entity that may have helped arrange for a lawyer to represent the client. What's being recommended is even outside of a court proceeding, a lawyer and a nonprofit entity, so long as the nonprofit is a 501c3 registered entity, that's one of the limitations, may be able to share legal fees with that organization to help us recommend or facilitate the representation for the client. So that'll be a recommendation that rule as amended go out for public comment. The second recommendation is to issue for public comment amended rule of professional conduct 1.1, duty of competence, that would add a new comment providing that a lawyer's duty of competence encompasses a duty to keep abreast of the changes in the law and law practice, including the benefits and risks associated with relevant technology. As you're all well aware, this committee's done a lot of work on drafting ethics opinions with respect to these duties and obligations. Hopefully it will not be seen as controversial. It's just a statement modeled but slightly modified after the ABA model rule statement comment 5, or their comment 8, to be added to our duty of competence rule. If agreed to, that too would go out for public comment. They also made a recommendation to issue for public comment a new rule of professional conduct 5.7, addressing delivery of law-related services provided by lawyers and businesses owned or affiliated with lawyers. And there's a drafting team that drafted a version of that rule and has been working to beef up some of the comments to that rule. There's 6 proposed comments. Beef up those comments by adding case citations to provide examples of the situations in which a lawyer acting as a fiduciary, although they did not an attorney-client relationship, had been disciplined. So it'll provide the citation to the case, and then in parens, lawyer acting as trustee, lawyer acting as real estate broker, lawyer as acting as agent for sale of property. And so we'll see what the board says about that. So that's kind of exciting.
So there's no effort to actually change that law or rethink that law substantively?
Well, I don't know that they
It's
can.
common law, you recall.
Correct.
It's not actually required. The disciplinary rule could change it.
Well, correct. I mean, I don't know that they're recommending a version of Rule 5.7 be adopted. It's not called, they went with the New York approach. It's not law-related services. They view it as a lawyer providing non-legal services. They must disclaim. However, the fact remains that this law exists, that this common law exists, and so the approach that they're taking, should it be acceptable by the board and the public, should it go out for public comment, the approach that they're taking is to list, notwithstanding this rule, all these examples in the fiduciary capacity. A lawyer has been disciplined, and a lawyer needs to be aware of that. I don't think that they feel comfortable in quote unquote changing the law.
Or recommending it.
Or recommending a change to the law.
Right.
I wouldn't describe, you're right, so I would not describe what they're doing as taking the approach you're describing.
Right. When does the opportunity to comment on that arise?
The recommendation goes to the board on Thursday the 12th, and then if the board agrees, it would go out for public comment. It takes about a week for staff to get a public comment posting and put it up on the website. It would go out for 60 days. So all these items, the 2 rules I also previously mentioned, I should say, this committee will have the opportunity to comment, provide public comment on, and probably our April meeting, which will be on a Thursday, the day before our symposium, will be our only opportunity to put some cogent, substantive comments on any recommendation that goes out for public comment.
When do they think that if the board acts, when will we have copies of that, of what they plan to do?
So, as I say, the recommendations will be part of the board item, so we can look at them soon, maybe by the end of next week. It should be posted by next Friday. But in terms of the formal public comment posting, it's hard to say. In my experience, it takes about a week to get them up. So if the meeting's on a Thursday, it certainly wouldn't be, I guess it could be posted that Friday. I would guess it'd be
We'll have a good deal of time to look at it before our meeting.
Absolutely,
Right.
absolutely.
So I'm sorry, I interrupted you, Andrew.
No, please, I welcome the question. Okay, recommendation number 4 is to commend to the anticipated State Bar Paraprofessional Working Group the key principles identified by ADLS in studying the concept of a licensing program that authorizes eligible non-lawyers to provide limited legal services. I'm not sure if I had mentioned this at our January meeting, but at the board's meeting on January 24th, they adopted a resolution to direct staff to draft a charter and begin to think of persons who might be best suited to work on a task force or a working group to consider what ADLS calls a paraprofessional program, what we might better understand to be a triple LT program. Some people view the term triple LT in a negative way, others don't, but they mean the same thing when I use those two terms interchangeably. And so the board took that step in January. At the same time, ADLS had been considering a recommendation for a similar program. And so what happened was ADLS, after the board took their action to establish a working group, they quickly just amended their recommendation to turn it into key principles that they wanted to deliver to this working group to consider as they provide the formal recommendation for a triple LT or a paraprofessional licensing program in California. And they've done a great job. You know, they studied LDAs, UDAs, paralegals, immigration consultants, how they're structured here in California today, how other states such as Utah and Washington have paraprofessional programs, and in terms of minimum qualifications, what you should be able to do, how it'll be regulated. They just flag things for consideration, concepts, and those will all be recommended over to the paraprofessional working group. Recommendation number 5 is form and appoint a new working group to develop a regulatory sandbox approach that will provide data on any potential benefits to access to legal services and any possible consumer harm if prohibitions on the unauthorized practice of law, fee sharing, non-lawyer ownership, and other legal restrictions are relaxed or completely suspended for authorized sandbox participants. And if you've been following this closely, Utah has undertaken developing a regulatory sandbox for legal services. Regulatory sandboxes also exist in other industries such as fintech, financial instruments, and I think Wyoming has done some for some medical products and tools and delivery systems. So this recommendation will go to the board. The board consider adopting a separate working group. It was too big a lift for ADLS to consider an entire regulatory scheme of a sandbox for California, but to get some people who are really well versed in that topic. There's already work products greatly created in Utah that they can build upon. ADLS has a detailed report of what a sandbox may look like. So a sandbox will not happen immediately. It won't happen should the board agree after March, but if the board agrees, then a new working group will be formed to create a sandbox. What a sandbox would do is allow an applicant to show that their product the benefits of their product will substantially outweigh the public protection restrictions that currently exist with respect to unauthorized practice of law, fee sharing, and non-lawyer ownership, such that it should be allowed to be deployed in the marketplace subject to regulation and restrictions, and they would be required to capture data about who they're serving, any problems that might arise, and then information gathered from these products in the marketplace is going to hopefully, the plan would help inform any substantive changes to rules or statutes with respect to those issues in the future. Questions on sandboxes? Okay. Recommendation number 6 is to consider recommendations for amendments to the Certified Lawyer Referral Service rules and statutes and relevant rules of professional conduct to ensure that they are properly balanced that they properly balance public protection and innovation in light of access to justice concerns, and with a particular emphasis on ascertaining if existing laws impose unnecessary barriers to referral modalities, including online matching services that are in the public interest. And so this largely comes from the Legal Match case. I'm sure most of you are aware of that case. They've appealed to the Supreme Court, and that request is pending with the Supreme Court, last I was aware. But this recommendation might be informed by the sandbox, because a lot of the innovative products that one would hope would seek entry into the sandbox would be those innovative ways to match and connect consumers with lawyers, and learning from the best practices and benefits of those products in the sandbox could help inform what changes might be needed for the existing rules and minimum standards with respect to lawyer referral services that exist today. Lastly, recommendation number 7 is to consider recommendations for amendments to the rules of professional conduct on advertising and solicitation, informed by the current American Bar Association model rules and the proposed advertising and solicitation rules developed by the Association of Professional Responsibility Lawyers, aka APRIL. In particular, a reconsideration of the existing designation of real-time electronic contact as prohibited by solicitation. So those are the 7 recommendations. More to come after the board meeting in 2 weeks on the 12th. But that summarizes the work of ADLS as of today. Any questions about ADLS? I realize that was a lengthy report, but I thought it would be important for you guys to get the details of that.
Is that available anywhere publicly?
Um,
Read?
Not yet.
Not yet.
It will when the board agenda posts.
I mean, yeah,
It's not posted anymore. Nothing happened at the meeting.
no, but the agenda items from the ADLS meeting is available. There were slight tweaks. Much of the substance is the same, but I agree with Mimi. I would wait. So if you needed something, there's probably
You're gonna
posted
wait a week.
materials.
Yeah,
But,
okay.
but
I
it's
just didn't know if those 7 things you talked about.
They will be listed on
Perfect.
for the board agenda, yeah, for sure, with some detailed reports about each one.
Okay.
Andrew?
Yes.
Andrew?
Yes.
Hi, it's David. I have just a quick question, and this is probably premature. On the LRS rules task force, I presume that potential changes include changes to the statute as well. Do we have any indication on that, or is that still to be decided?
So yes, I think the recommendation is to study both the state bar rules, which set forth the minimum standards, but you obviously couldn't recommend much changes there without also addressing 6155, which really governs.
Okay.
And we would need agreement with our legislative stakeholders to make corresponding changes. And again, that recommendation might be folded in the sandbox as opposed to a separate working group to take that on right away. So we'll have to see what comes of that. But to answer your question, yes, it's my understanding you couldn't do one without the other.
So just so I understand, the sandbox concept means someone could come along with a demonstration project in the LRS field that essentially abrogates the statute, and they'd be allowed to demonstrate whether that would have a beneficial impact.
That's correct. There would be an application process for products and or business models, delivery models. I don't have no application's been created, so this is all theoretical right now. But yes, to answer your question, someone would come with an application, an example of a product, demonstrate the public benefit, the steps that are taken to mitigate any harm. And it's the concept of a sandbox that would say if that product or business model or arrangement is approved, you are free to quote-unquote enter the sandbox. And by entering the sandbox, these restrictions that would otherwise apply to you are either relaxed or removed. So you would not be subject to 6155 in the example you're providing.
Okay.
That was an exceptionally helpful report, I thought, and I don't think you need to apologize for the details
Okay.
what worked out.
Thanks. Okay, really quick, I'm almost done. Just a reminder, the application deadline to apply to this committee is March 15th. That's also 2 weeks from Monday. Strongly encourage you all to consider anyone you may know who's interested and would really help the work of the committee. We would love to have the best of the best apply to this committee, so I encourage you to brainstorm about folks who might be suitable to apply. And then lastly, this is our last meeting before the symposium, also will be held in this room, which is Friday, April 17th. I think we're all pretty well set up. I know there are a couple last minute changes, but we got the program descriptions are coming in. Most of the panelists have been identified. We got our save the date out. We'll soon be getting the application form, the registration form, excuse me, up so people can begin to register. I've reached out to the current chair of the board, Alan Steinbrecher. He's agreed to provide the welcoming remarks along with Steve, our current chair of this committee. So that'll be great. And then also a representative from the California Lawyers Association will be here for the latter half of lunch to provide Richard Zittrain with the Harry B. Sondheim Professional Responsibility Award that used to be administered by the State Bar of California. But now all awards are being, not all, most of the awards previously provided by the State Bar of California are now being provided by the California Lawyers Association because this is an award with respect to professional
They couldn't
responsibility.
be bothered to schedule an event for it themselves.
But the Ethics Symposium is an excellent event and opportunity to expose all ethicists up and down the state to our good friend Richard, and we'll look forward to that. Okay, that was extremely long, and thus concludes staff report, unless Mimi have missed it. Thank you.
Okay, so that covers the announcement and staff report. We have now the approval of last week, the report of our business last meeting. Does someone want to move the approval of that?
1 second, real quick. David and Brandon, are you there?
Yes.
You guys should have received an email or a Skype meeting invite from Lauren. If you want to join that meeting, then you can see what we do on the screen here in the room.
Okay.
And if you don't want
That
to-
would be an invitation by email?
Yes, she sent it to you, I don't know, a few minutes ago, maybe about 10 minutes ago or so. So if you click on the link and just open in your web browser, you'll be able to, and you join the meeting, you'll be able to see
Okay.
what we're doing on the screen in regards to drafting. And then also you should mute your computer though, because we'll end up getting an echo.
Okay, thank you.
Right. Okay, go ahead.
So do I have a motion to approve the record of our prior business?
So,
Our
second,
action summary?
okay. All right, Stephen Bundy,
Yes.
Ken Bacon, Sarah Banola,
Yes.
Kendra Basner,
Yes.
David Carr,
Yes.
Justin Fields,
Yes.
Toby Inlander,
Yes.
Adam Koss,
Yes.
Brandon Kruger,
Yes.
Amber Lee,
Yes.
Nina Bush,
Yes.
Marshall Whitney. Thank you.
Okay. I think what we'll do now is move to discussion of the various projects that are underway. Justin, do you want to lead with the
Sure.
litigation, your work on the litigation finance revision?
Sure. So just to set the stage here, this is interim number 14.
Just sorry to interrupt, friendly reminder for everybody, please use your microphones when speaking. The green button is intended to indicate that you are live.
Okay. So just to set the stage, this is interim opinion 14-0002. And this opinion had gone out for public comment. In our last meeting, we discussed those public comments from various individuals and local bar associations. And the consensus was that we should consider those comments and revising accordingly, and then also consider if or whether to discuss or whether a lawyer has a duty to advise clients about litigation funding, and then also whether we wanted to include a fact pattern that basically addresses the ethical duties, obligations, concerns when the funder is directly paying the lawyer as opposed to what was set forth in our original opinion, which is that the funder pays the client, who then in turn pays the lawyer. So I've put a couple discussion points out here for those two items that we discussed, the duty to advise and this new scenario. By no means are they comprehensive explications of what could go into our opinion. This is my first opportunity to wordsmith this opinion, and I'm very much open to the various viewpoints and thoughts that you all have so that we can decide whether we want to make some of these proposed changes or sort of stop where we had been previously in terms of the fact pattern. So let me go through a couple of the changes and kind of highlight what I previously just mentioned, and then I'd love to hear what everyone has to say. So one thing that we did throughout, as you'll probably see in the digest, reference to the lawyer's interest, is that we removed the discussion about referral fees. There was a fact, you might recall, about a $500 referral fee in the consensus. Really in every comment that we received, and I think in this room at the last meeting, was that we should pluck out that fact pattern. So I've tried to do that here. And then, very simply, trying to keep this as narrow as I can so that we don't turn this into an unwieldy opinion. I've tried to keep this new scenario where the lawyer is funded directly by the funder very simple. So I basically just adopted, at least for present purposes, the fact pattern that we lay out in detail in scenario 2, and basically say, consider those facts except this change where the funder is now paying the lawyer directly. And, of course, we might need to include some nuances there, but at least for present purposes, I thought it would be best to keep it really simple and just focus on this new critical issue and whether we want to take it up. And then if you turn to page 3 of the red line, right before we get to the discussion section, we also had a fair amount of dialogue at the last meeting about whether to remove some of these sort of analogies to other types of arrangements, such as in the insurance context, tripartite relationship, and I think our consensus was to remove those sections. And having now read this with those sections deleted, I think it reads a lot cleaner, a lot more focused, and so my inclination would be to maintain what was our consensus at the last meeting and to keep those sections out. And for me, philosophically, I also think that the shorter our opinions, the better, so that we focus on the issues and make sure that our full opinions are read by our audience and understood by them, and we don't get into too many distractions. So then, if you turn to page 4, under the heading that's now reads duty of competence and duty to communicate, this is where there was some, I'll call it general discussion about the duty to advise, and the concern was raised, well, do we want to flesh out whether there's a duty to advise? Do we want to refine this to avoid a discussion about whether there's a duty to advise, and sort of move away from addressing that, which I think the fact pattern presently would allow. I think the fact pattern as written is something to the effect of the client has already asked the question, about litigation financing, and the lawyer has agreed to provide the advice. So we don't then have to answer whether or not, as a threshold matter, the lawyer has a duty to advise, because the lawyer has taken on that responsibility in our fact pattern. And so this is the place where we discuss whether we wanted to address Rule 2.1. That is, whether there's a duty to advise under Rule 2.1, that an option for a client who is having concerns about how to pay for litigation might be able to explore litigation financing as an option. And I think our options are threefold here. One is we can continue to punt on this issue if we don't feel comfortable addressing it for whatever reason. The other is we can take it on directly and issue a statement that there is a duty to advise, or there isn't a duty to advise, or perhaps it depends on the circumstances. My inclination, which again I'm here with an open mind to this, is that looking at 2.1, there isn't a duty that a lawyer has to advise a client that an option to pay or to finance the litigation is litigation financing. And I would be concerned if we were to say something very declarative that was contrary to that, because that would be, I think, imposing a duty on many lawyers in this state who know very little about litigation financing and suggesting that they are in breach of their ethical duties if they don't advise their clients about how they could possibly pay for their lawsuits. So that's my present thinking on this, and I welcome your thoughts about our options with respect to this issue. And then there's some wordsmithing issues that I took care of, as noted, as we get along to page 6. And addressing the first hypothetical, I removed the references to the $500 referral fee. And then in connection with that, did some further wordsmithing to incorporate back into our scenario 2 some of the discussion about 1.7D, as you'll see in the red line there, so that we don't lose that, even though it was previously connected to the referral fee issue. The issues there in 1.7D and 1.4 that are in the red line, I think, are relevant to scenario 2. So I included those back in. And then finally, there's this new scenario 3 that I've already mentioned. I kind of put together a bare bones discussion of what I think are 3 of the key applicable rules, 1.8.6 and 5.4. And just so that you could see, for discussion purposes, what we might be addressing in this scenario and how it might come out. I fully recognize that we might very well want to flesh this out, perhaps tie these rules to the facts of our scenario 2, assuming we're going to use those facts, and provide a little further guidance under that fact scenario, how these rules would play out and what ethical issues the lawyer should be aware of or must watch out for if accepting payment directly from a funder. And one thing that occurred to me, and I talked with Andrew about this briefly offline, was this scenario is different than what I think is not uncommon, which is that, say, a family member will help fund another family member's litigation for whatever reason. This is very different than that scenario, and I think there are much greater concerns because under our present fact pattern, this lawyer has an ongoing relationship with the funder. And unlike sort of a family member just trying to help out a family member, there's a business aspect to this that I think is very concerning in terms of wanting to make sure that lawyers who might engage in this type of payment arrangement are making sure that their independence is not compromised. And that, I think, is particularly so in this fact pattern where the funder has an ability to basically direct the change of counsel, which isn't really an issue that you would think would come up in this similar situation I'm suggesting. Happens quite frequently where a family member is helping pay the fees of another family member. That family member probably doesn't have some clause saying that he can fire the lawyer, whereas that's a concern here with more complex relationships involving a funder and a lawyer. So these are some issues that we might want to tackle if we keep in scenario 3. So I offer that as some food for thought and as we discuss that. And that's kind of the gist of what I've tried to capture in these red lines and what I'm hoping I can get your feedback on.
Thank you. I think you and I are the committee, Nina, so maybe we should go next. You want to go first? I'm happy to go first.
Yeah, go ahead.
Okay.
I'll let you go on the next.
My thought, so this is very promising. I agree with the deletions. I think that they streamline the opinion without really taking anything away at all. My thought about, I'm just going to focus on a few things. My thought about 2.1 is that 2.1 is not only just about advice, it's also about independent professional judgment. So it feels to me that you could discuss it, have us heading below duty of competence. You could have a second heading that says candid advice and independent professional judgment, right? And then you could discuss 2.1. As for the approach, and then the further discussion of 1.7, 1.8.6 is protecting the values that are instantiated in 2.1, particularly independent judgment. So it would read naturally to have a paragraph about 2.1 first. On the question you raise of whether we should opine on whether there's a duty to recommend litigation finance, I don't think we should. I think it's too much of a duty of care issue, and not one that we can anchor in sort of, we do duty of care sometimes around things like confidentiality or technology, but those are sort of generics. I feel like this doesn't work that way.
So to clarify, Steve, not to cut you off, but with the 2.1 discussion, you're suggesting that it's not going to be a discussion that revolving around that ultimate duty,
No,
but
absolutely.
related to the issues of the person who's already engaging in litigation funding and the duty
exactly.
to advise related.
Yeah, so that exactly is my point. I think the hook is exactly what you said, that they've asked, and so you now have to give independent advice, right? Candid and independent advice. But, and maybe whether we have a footnote that says we're not opining on whether there's a duty if not asked is an open question, but that would be the way I lean myself. So I think my instinct is like yours, but I do want to make more use of 2.1 than we currently do in the opinion without hooking it to the duty question. So that's my first big thought. My second big thought is that we have a really good discussion that survives from the earlier version of the opinion about what it means to be professionally independent when the client is giving up some control of its litigation, right? And it feels to me like it would be natural to try and apply that discussion in scenario 2 to the condition that says that the funder has the right to fire counsel, right, or to approve replacement counsel, or whatever the exact language is, right? Mm-hmm. That seems like a natural occasion to show how our analysis of what the lawyer's obligation is would work, which is to say, client, you're giving up something, right? It's consequential. If at the end of the day we get to the question of, I'll be with you to help you figure out, you know, how to, I'm still with you on helping you to figure out how that works, right? Or something like that. And it gives you a chance to sort of show how that earlier analysis from the ABA opinion applies to a concrete problem.
So whether or not we go down scenario 3, in scenario 2, add a discussion about this independent professional judgment and all of that piece.
Right.
Okay.
And you could change it around. I don't have any commitment to the particular restriction on the client's freedom of action that's specified in our current scenario 2. Right? If you wanted to find something you thought was more realistic or raise the issues in a more effective way, I wouldn't have a problem with that.
Okay.
And then On scenario 3, I think what you got, I don't have that much more, I don't think there's that much more to say, except that you might want to say that the rest of the analysis is the same, right? And these are the changes that you see, something like that. One last thought, this is very minor. At page 10 in the discussion of confidentiality, it says, the courts have considered whether a funder in an attorney-client privilege, presumably the lawyer communications about the funder about the case would also be protected. Many people would say they're protected by work product as well, right? And so it may be that that's another layer of analysis there. Not many people don't think that work product is limited to what you actually write down. Okay. So those are my thoughts.
Thank you.
Yeah, I agree with a lot of the things that that Steve has said on those issues. I think there's a couple, some minor things. I think there was a suggestion on the issue of configuration about whether it should be the obligations when a client enters into a litigation funding agreement instead of they're being funded by a third-party litigation funder, especially if we have the scenario 3 or just kind of wordsmithing that.
Yeah, if we keep scenario 3, I agree. We got to go through this and refine certain sentences that assume scenario 2.
Okay, so I'll leave some of those little comment things. I won't get into those now. There's just some word things. But yeah, on the whole, I like the way you broke up scenario 3. I think, given the feedback we got from a lot of the public comment, which I thought was really helpful, that's a good thing to address. I think also just in terms of that first paragraph under the introduction to litigation funding, I think that second sentence, and we'll kind of wordsmith that, but I think that second sentence in particular in the first paragraph is overly broad in terms of what litigation funding is, because it's not just plaintiffs, it's not just,
You're saying this sentence, litigation funding is the practice where?
Yeah,
that one? Okay.
yeah. It just it's not always as related to plaintiffs, and it's not always financial recovery. Sometimes I think someone pointed out there's security involved, but not that we need to tell people what it is, but if it relates to our fact pattern we're describing.
Right.
And on the discussion about 2.1, my first inclination was, I like what Steve's suggestion is on 2.1. I don't want to opine on, I agree that I don't think we should say in every circumstance a lawyer has a duty to tell a client about litigation funding options. I think we need to be careful though. I like the language that we have in here already, but in this particular fact pattern, it's clear that the client is expressing concerns about their ability to to pursue a claim and finance those. And so in that context, based on the 4.1, which I think we describe, in this particular fact pattern, there would be an obligation to discuss that with the client or to tell the client, I'm not, I don't have the, the experience to talk to you about litigation funding. That's an option for you that you should consider in some context. I don't want to suggest under this case where a client comes to, experienced plaintiff's attorney, and I'm assuming that they obviously are aware of these various options, that they would, if that was an expressed concern, that wouldn't be something that would at least be identified to a client as an option, and whether they could provide advice on it or guidance would be another issue.
Yeah, I want to go through this fact pattern again because I want to make sure that it's clear. Just because the client comes and raises the question, doesn't mean that you have a duty or obligation to advise. You might have to tell that client, sorry, this is not my expertise. I can't advise.
Right.
And that might be fulfilling your obligation.
Right.
So I want to make sure that how this reads makes that clear, that just because the client asked you about litigation financing, you don't have a duty to then opine on something that you don't understand. But if you do know about it and you do understand it and they have asked you about it, here are the concerns and considerations, etc.
Yeah, and I think at least in this it's a pretty commonplace that's available, and it may not work for any particular situation to identify, hey, some people chose this, that's not something I could advise you on. If you don't know about it and you're not in a position where you feel, that you can confidently advise on that issue. But so I just think it's sort of that consideration in light of whatever the facts sort of flesh out to be on that particular point. I don't think that 2.1 suggest that there's any kind of affirmative like duty to do that. And I think having it in the context of once they are engaging in they're going down that path, I agree that there's some good language there about independent judgment and the candor that could be tied into the next, obviously we talked about independent professional judgment, Rule 1.7. So other people can comment about that too. And then, yeah, I agree with the scenario 3. I do think there's not a sentence incorporating sort of the regular analysis or the existing analysis from scenario 2 into scenario 3. We should incorporate that or obviously just relate to the rules. Like there's a 1.7D issue and some of those issues that are obviously like present, and it could probably be dealt with in a sentence like the same analysis applies. But obviously I agree all that analysis would apply to this fact pattern as well. And then I think there was some feedback about the fact that we have a lot of cases in here that are non-California cases, and if there's better cases and stuff like that on some of those issues. I mean, I know you incorporated that Laguna Beach case, which is good. And I mean, maybe we come out and say, hey, I mean, I didn't look at all these cases and say like, oh, there's a better California case or there's not a California case and that whole thing. But I just think it's something like in the final, that we can review and say, hey, are there better?
Yeah, I didn't, I chose not to remove or revise these long footnotes that include a lot of non-California authorities. I'm thinking we might trim them down just a little bit in terms of the final, so it reads a little bit better. I'm not a fan of string cites unless we really need it. I took a quick look at recent California 9th Circuit cases on litigation financing, in particular with respect to the privileges and protections that courts are recognizing. And the most recent cases I found go to protecting, of being protective, but they were in the context of the funding agreements specifically, as opposed to communications involving the funder more broadly, just in terms of these most recent cases that I saw, and they were very clear that there was work product protection for the funding agreements, but it didn't go broader than that. So I didn't end up, at least at this point, including more recent cases or cases that are 9th Circuit or California. But in terms of the next iteration, I'll take a closer look and see if there's something we can do on that point.
Yeah, I mean, I think the common interest argument is like particularly compelling argument, like with respect to that, and some of the cases on that extension of the, the non-waiver with respect to the privilege and like with the common interest of that concept,
Right.
I think is helpful. And then I also will just second that I agree with like the elimination of the insurance discussion and the things that you eliminated. I agree because I just think that made it overly confusing, and I like this approach better. So thanks for that work. And that's all I have.
Anyone else would like to offer thoughts, Justin, for the next round?
Hi, this is David. Hi, I'm in agreement with Steve's comments. I think it's important, I don't think we should categorically rule out under some circumstances that a lawyer might have a duty to advise the client on litigation funding, but I don't think we should, I think we just deal with that in a footnote and say we're not going to address that, but I wouldn't want to close the door to that possibility. And I agree with the inclusion of some discussion of Rule 2.1. I think Rule 2.1 is a new rule in California and an important rule, and that's one flag I think we should try to salute every chance we get.
Thanks, David. Agreed.
Other thoughts? Okay. Justin, thank you very much for turning this around.
Sure.
Coming back from parental leave. We appreciate it a lot. Okay, that's now we have 17001 advising the marijuana business. So this is, as you all know, the second time that this opinion has been out. We got two comments, one from the Orange County Bar Association and the other from a lawyer named Janess. And I should alert you that there's been some news coverage. We've had there's an embarrassingly poor article in the Daily Journal that contains a couple of outright errors of fact, which we're considering about whether, I think Andrew was considering with the state bar's media people, whether we should request a correction because the errors are pretty, they're bad. They're not, and they make it look like we're doing something that we not only don't have the power to do, but didn't do, which is enact a change to the California Evidence Code.
I think the article came out like 2 days ago or something like that in the Daily Journal.
And there's also much better coverage that Dina found in Law 360. It's a much more balanced and thoughtful presentation. So anyway, we're going to think about what to do about that, but it appears that some of this may have come from one of the commenters. They knew may have been the source of some of the coverage. In any event, the Janess comment, my own view is that it's sort of a non-starter. It basically takes the view that that because this conduct may be a federal crime, we shouldn't say anything about it except to write a one-sentence opinion saying that you can, not exactly clear exactly what that one-sentence opinion would say. But it seems obvious to me that you can't possibly write a responsible one-sentence opinion on this. It's one thing if the state bar prosecutor's office were to say, we decline to exercise prosecutorial jurisdiction with respect to this conduct, right? They could probably write a 1 or 2 sentence statement, and that would be equivalent to what's been done in, say, Massachusetts. But we have to, if we're going to opine, we have to deal with the difficulties. And so the second set of comments is from Orange County, and there are sort of three basic questions in that, and I'm condensing and reorganizing their thoughts to try to make them as clear as I can. One is that they object to our use of the rule submissions and the materials attached to the rule submissions to the Supreme Court are referenced to them as legislative history and as suggesting that they're relevant. We've had a great interchange, there's been a great exchange within the bar, and Randy DeFontorum, who is our friend on high, has come up with quite a variety of cases where rule filings have been cited and quoted as legislative history, which completely removes any unease that I might feel about that, about doing that, saying that. You will see in a second when I run you through the changes, I changed the language to drafting history to make it a little bit less contentious. But it seems to me that the material is clearly relevant, and we should leave it in. Then there's a concern with what they suggest there's a problem with the, quote, integrity of our analysis, right? And that seems to have something to do with the fact that we should be thinking about the possibility that providing that somehow there's a textual argument that we're ignoring, that providing advice or assistance or counsel or assistance, to use the terms, to a marijuana business about California law doesn't violate 1.2.1a, right? Because it isn't assistance and the short answer, it seems to me, is that textual argument simply doesn't work. You need to, it's clearly assistance within the meaning of 1.21a, right? And therefore we have to find hope in 1.21b and in the comment from the Supreme Court construing 1.21b, and so, which is what we've done. So I think that to the extent that it's possible to have integrity of analysis on this subject, we have it. The third point is that somehow our conclusion with respect, particularly with respect to assistance, is too strong. And the only thing I could see that, and we'll come back to this, there's one point where we do say that something is clear, where we probably should say something is not quite so strong as clear. But generally, I don't think we've overstated the case. And finally, there's the notion that we're giving too much comfort with respect to conduct that is in violation of federal law. And I think that was a fair charge with respect to our earlier draft. But this draft is very clear that we're not offering any comfort with respect to federal law at all, but only that we're speaking only with respect to the discipline issues, and only with respect to the discipline issues that would arise prior to and in the absence of any federal conviction. So I think, so my instinct is we don't have to change that. Let me just run you through some minor changes, if you can pull up the opinion image. I think the first one is at page 2, it's very minor. It struck me that this is just a stylistic change. At the same time, possession, commercial production, distribution, and sale remain unlawful under federal law, comma, and violators rather than where violators. So it doesn't actually change the substantive meaning at all, but it's stylistic. I think the next change maybe is at page 6. Does that sound right?
Or just change to the 5.
Oh, yes, right. Where a necessity defense is not provided by statute rather than in statute.
Then page 6.
And then page 6. This is just putting in the restatement rather than it. So these are, as you can see, not very compelling. And then the only changes that have any any possible substantive weight are at the top of page 8, and you can see them. This is the first set of changes in the paragraph at the top is simply designed to make the argument a little clearer, right? Those state or local laws that conflict with federal law, and we believe that the inclusive term California laws is, however, broader than that, encompassing assistance in or complying with all California laws, and all is now emphasized, right? So to make the point that, just to make our point a little clearer. And then this is the only change, this is the change in response to the Orange County comments. The drafting history of 1.21 also indicates rather than makes clear. That's all I've got. So, other folks?
I think this is great. I agree with the response to the comments. I also just wanted to say for the record, that as we all know on this with this opinion, that this was the second time that it was out for public comment, that it was out for public comment previously, and we got a lot of really great feedback, which we reviewed and you diligently, the committee diligently and subcommittee, considered and responded to, and addressed in this second iteration that was then out for public comment, which I think really has addressed a lot of the concerns that have been out there on these issues, and I think it's very thoughtful, and I agree with these. These are just more like minor little tweaks to language, right? But
yeah, there's no substantive changes at all.
Yeah. And those are my comments.
Sorry, I'll go last.
Well, my only comment.
This is Brandon Krieger. Oh. Hello, this is Brandon Krieger. I'm sorry because Stephen rightfully mentions that the Evan Jeunesse comment is a bit of a non-starter. But I will confess, it sort of stopped me cold and scared me. And I'm wondering if anyone else had a similar reaction. I agree that there's not too much to discuss, because if we are struck that way by the Evan Jeunesse comment, there's nowhere to go, really. But it really did make an impression on me.
This is David. The Jeunesse comment is consistent with feedback I've gotten from various people, mostly in the federal law enforcement community. that think the whole concept of this is wrong, and I don't think they are correct, but it's a pretty good example of the vehemence that some people have toward this whole issue in a specific corner of the legal world. So I don't think it changes what we do, but it is a little jarring to read.
Well, I totally get that. I mean, that's always been the problem, right? From the very first time we discussed this, there is difficulty here because any conduct that involves counseling or assisting compliance with California law necessarily raises the risk that that conduct will violate, the lawyer's conduct will violate federal law. There's just no escaping that issue. I guess, I think the hard question is what would we want to say about that, if anything, in the opinion, other than what we've already said. This issue arises in every state which has marijuana laws, and it's been resolved essentially the same way in every state that has marijuana laws, right? So we're not alone, and it's also the same way that it's been resolved by other ethics committees in this state that have considered the issue, right? So I think it's hard to know what to say. Does anyone else have thoughts about what else we might say?
Well, I just wanted to make the comment that at our recent meeting for the San Francisco bar, that same issue was brought up.
Did people mention that they'd already written an opinion on this effect?
I was a little bothered by the fact that this has been out before for public comment and no one on the committee raised any issues in the past, but they brought it up this time and it was too late for anybody to write a public comment and submit it on time for our committee. But it struck me, and I know you and I are very close to this and have looked at it a million times, in my mind it's very clear that all we are talking about is whether they will be disciplined in California under the ethics rules. But I wonder if, from somebody who's a little further away from this opinion, if maybe it's not so clear and if there's some way that we can make it more clear up front. Obviously there's the risk, but if someone's reading this thinking that we're trying to have a further reach than we are, then maybe we need to make it more clear. The second comment I was going to make is what you talked about before about the legislative history. I like the changes that you made, and I'm just wondering if maybe we can add in the beginning of that paragraph something along the lines of, this is not binding but instructive or something. Again, I think some of it is we are familiar with this opinion and we've talked about it at the meetings and it might seem very clear to us, but somebody reading it for the first time, we might have to be a little bit more blunt.
Do you think the word indicates might capture that? It's not, it doesn't exactly suggest that.
I think maybe it might be worth putting in there directly that although not binding, and then continue.
No, I don't know. We're not actually, we're using that as evidence for an opinion that is itself not binding.
Right, we
so
understand
I'm not quite
that.
clear why we would go sort of double not binding.
Well, I think we understand that. I just wonder if the reader is going to pick up on that. Just a suggestion. But in other words, both of my comments are more for, the first-time reader who doesn't have the benefit of our discussions, and just to maybe make it a little bit more obvious what our intentions are with this opinion, both as to the California disciplinary portion, the overriding objective, and then more specifically when we put in this drafting history.
Doesn't the paragraph at the bottom of page 5 cover this? And it says, that last sentence seems to say you might be prosecuted for doing it.
Yeah. I mean, I
thought
think
this
it's
was
pretty
covered, right?
clear, but apparently it's not, because all these people are making these comments.
But I mean, the question about whether we can ethically
We don't
advise
even know whether
clients.
they read it, though.
Yeah, right. I mean, the question is,
Well,
the answer is,
Jeunesse is not, I mean, it's not a responsible comment, right? One sentence opinion,
right,
it's laughable,
Right.
excuse me, as a suggestion for what kind of guy, California lawyers actually need some guidance. One sentence would be in effect inviting them into the trap.
I don't disagree, but I just wonder if, and I don't think that's the way we should go with it. I like the opinion. I just wonder if we should make it more obvious, or maybe stick this part up front.
Hold it or something, underline it.
Yeah, maybe.
So hearing your comment, one thing that I can think of that we might consider, and again, I don't feel strongly about it, but assuming for the sake of discussion, we're considering foregrounding some of these scope limitations or potential liabilities for lawyers, that sort of thing. I thought it was pretty clear between the scope of the opinion section, that's section 1, and then what Adam just referenced at the bottom of page 5 about still being subject to state discipline based on a conviction. I wonder if we include those, the scope of the opinion and that point I just referenced from the bottom of page 5 together, and move the scope of the opinion in a more foregrounded way up front so that no one can seriously claim that these scope limitations and potential liabilities were not made clear right up front.
Section, maybe?
Yeah, or before we start the statement of fact.
Before the statement of facts might be the best
Yeah.
place to put it. They make it
So then how can anyone say, before they even get into the meat of it, that we've given them the scope limitation, we've given them the concern about state liabilities. Now here's our opinion subject to that.
I mean, I think we say it, and it was a very frustrating conversation for me because I think it's very obvious, but clearly others are missing it. And I know the people on the San Francisco Bar Ethics Committee had read the opinion. So it was a frustrating conversation for me. So I'm just putting out there some suggestions on how we can make it more obvious to the extent it's needed.
We can just put it before the issue. This has nothing to do with criminal prosecution. We don't have anything to do with that. I mean, like it could be the first thing in the opinion if that's how concerned people are.
Well, or I mean, it strikes me that it could logically go right after it says, lawyers wishing to provide such services are under assembly concern will subject them to discipline for professional misconduct, right? So we go on and then he said, and then we could then put the scope paragraph immediately following, and it would then say the conflict raised difficult questions is limited to the issue of a lawyer's obligations and professional discipline. So you make it absolutely clear before anyone gets, I mean, I don't think that's a bad change at all.
I didn't follow, Steve, what was your first?
Which paragraph are we talking about?
the first paragraph in the discussion, which is scope of opinion, I think the suggestion by Justin and,
Because you put it before statement of facts on the practice.
and just saying scope of opinion. I mean, it's not gonna change substantively anything in this opinion, it's just reorganizing it.
But you had other language?
No, and then we take that out, and let's go on down, and then we can make whatever change.
You want that last sentence from page 5 still?
No,
No?
no.
Okay, you don't want the last sentence. Okay. So go from this sentence to that paragraph.
But I think don't you wanna put scope of the opinion above it?
Do we need?
Or no?
Yes.
Yes. I think that heading would be helpful because it probably needs to be all caps, yeah.
Okay.
Do you want to?
But that would be in the center, and then caps, all caps like statement of
Yeah,
facts.
yeah.
Do you want to, does it help to move the last paragraph on page 5 as the second paragraph under scope of opinion?
Well, that's what I had there.
Did you move it?
So-
I did, but then they told me to take it out.
Yeah, I don't know that we need to move it, like completely lifted as much as if we want to refine what's already in scope of the opinion, just with some little wordsmithing to convey the issue raised at the bottom of page 5, which is the prospect of becoming subject to state discipline based on a conviction. I think that the concept is already in the scope of the opinion, but to the extent we feel like we want to highlight that even further by wordsmithing, some of these 1, 2, 3, 4.
I think that's a good
scope of the opinion. We could, but I don't feel strongly about it.
Here's my sense of this issue specifically. We should take some time I'll take some time over lunch with any of you who are interested to figure out how we can make the point clearer, right? To the extent that without changing the substance of the opinion.
Yeah, agreed. Yeah, agreed.
And I think that that's worth doing. I don't actually see a need for a substantive change, but Toby and those of you who suggested that we want to say something like the sentence at the bottom of page 5, somewhere very early, that strikes me as not an unreasonable idea, right? We could say something like caveat emptor in so many words, right? And it just be clearer. I do have a concern, and I don't want to preempt more discussion on this, but Andrew, I have a question for you, which is, are we walking into something here, right? We've walked into things before. I have personally walked into things before where, are we going to find that, for example, OCTC doesn't agree with this view? Are we going to find out that the State Bar Board of Governors runs away from it? What kinds of, are people going to be able to follow, people within the bar are going to be able to follow our reasoning?
Well, I can't
Well, no,
speak for how
what's your
anyone
sense? What's your
internalizes
sense?
or understands. My sense is,
Because I don't want to put out an opinion. I don't want to put out an opinion that's going to get shot down because people are gun shy about actually addressing these issues.
so listen, several things. One, this has been out for public comment twice, so if OCTC wanted to comment, hopefully they would have said something by now. The board arguably hasn't been presented with this issue, so I don't know. I would think it's safe to say it would be a case of first impression for them when the board agenda comes to them. They do get briefed on what's coming to them in advance of any meeting, so they'll, at least the chairs of each subcommittee, so I'll be able to raise the fact that this opinion is coming their way. But the other thing that's not being addressed here is the fact that Comment 6 exists. The Supreme Court asked for it to go back to the Rules Revision Commission for further careful consideration. The opinion does a very artful job of describing that the law exists in California. How can these folks benefit if we're going to say or not issue an opinion that they too can seek legal advice as to how to comply with state law lawfully and appropriately. They're very compelling arguments for why this opinion should be issued. I mean, just on background, we've had many interested parties for 2 or 3 years calling saying, well, where's COPRAC's opinion on this? And a lot of it was, once 1.2.1 and Comment 6 was beginning to be drafted, we could turn and say, well, let's wait for that language to be finalized for which we can analyze ourselves in an ethics opinion. So, I mean, I can't.
There was a request for this opinion, if I recall.
Oh, yeah.
Many requests.
Oh, yeah.
Yes.
Yeah. I mean, yes. So, but.
That's all very helpful.
Yeah, I mean, we'll make you can come to the board meeting if you so desire. I can take the temperature of the committee members if they think they need that. The other thing is, and this is not that it's off the record, anyone could attest to it, but as Comment 6 was being drafted, as you see in the public comment, there was questions about, well, what does drafting, administering, interpreting, or complying mean? Well, let's write an ethics opinion. We'll have COPRAC flesh that out. that was part of the conversation around the table. I was in the room when the Rules Revision Commission was developing this. So, and it's not just, as we discussed, marijuana laws, there's immigration law, there are other conflicting situations, tribal law, which I'm not familiar with, but, you know, casinos, there's taxes, you know, there's all kinds of issues that might arise. And I thought the opinion was clear that federal risk of federal prosecution exists, notwithstanding this opinion. Much of the analysis relies on that. Why does the conflict exist? Because one or both of you might be prosecuted under federal law. That's why we're talking about this issue. So to think that the opinion protects you, immunizes you from federal prosecution, I mean, it's just a non sequitur. But it is a 16-page opinion, and maybe not everyone is getting through it. So anyway, it's a long-winded answer, but this is such great work.
It's a great answer.
We should make, you know, we'll make our best case. It's unfortunate that our...
Hi, this is David. I have a comment. I think when we talked about this, I had raised the issue of, you know, giving lawyers a false sense of security, and I think we've made some changes to the opinion based on that concern. I'm so concerned about that in light of sentiments like Mr. Jeunesse. So reading the digest, it strikes me that one small change that might have a fairly large difference is flip the order of the paragraphs in the digest, remove the however and put paragraph 2 at the beginning, and then have paragraph 1 following however, so that I guess the stick and not the carrot leads the digest.
David, I'm sorry, can you please identify exactly the language that would begin the digest? A lawyer may not advise a client.
The language after however, I would suggest flipping the order of those paragraphs and make that paragraph come first, and have the first part of the digest come after however.
And then the next sentence, would you use however there? However, a lawyer may ethically advise?
Yes.
Okay, and then the rest remains the same?
Yeah, pretty much, and maybe, you know, probably needs a little tinkering to make sure everything is grammatically correct. But just to raise the unpleasant topic first, and the more pleasant subject after that.
Well, the only part I have with that is that it feels I guess there are two things to say about that. One is I feel like the key is a lawyer may ethically advise, right? And we could say that, you know, we could maybe it's better to say I think it's right to want to clarify and narrow, but my instinct is to make the ethical point even clearer by saying under the rules of professional conduct, right, and the State Bar Act, right? Right, lead with that, and then I'm just offering a sort of alternative way. The State Bar Act, comma, a lawyer may ethically advise, right? And but I think the order is important, right? And because we're not saying anything about criminal if we lead with a lawyer may not advise a client to violate federal law, what we're doing is I guess the other way to do it, we could do both. We could say, I'm sorry, I'm thinking out loud here. Under the State Bar Act and the rules, under the rules of professional conduct in the State Bar Act, comma, a lawyer may not advise a client, right? And then come back. However, a lawyer may ethically advise a client concerning. It's not the way we lay it out in the opinion. So to me, it doesn't, I prefer to keep it the order as it is, but what are people's thoughts on David's comment, I guess?
I think that we should keep it as it is. I mean, I think you could add your, I mean, that's
You
just
think
my vote.
under the rules of professional conduct in the State Bar Act?
Sure, I mean, again, this is an opinion about ethically advising
Right.
clients about the rules, and I think that, I mean, I appreciate, it's always good to be mindful of like the audience, and if there's a sense that like, we're not making the point about the risks involved, and I personally think the opinion, really highlights that well throughout, those particular risks, and, I think that I would just vote to keep that structure the way it is. I like the change with the scope. It would be helpful if people read like the entire opinions. And I know it's a long opinion, but at the same time, you can't just kind of like, like the identification of the comments about like, oh, there's this risk for 5 to 10 years. Well, that's directly in our opinion, which we identify that particular risk. So it's kind of frustrating when you get feedback where it doesn't feel like people have really thoughtfully, I'm not talking about you, David, I'm talking about, the letters, but that's my view. Other people may have a different view.
I'm a little concerned about the phrase in the State Bar Act.
Well, that's why I was gonna look and see if that really applied.
Why?
So, I mean, make the argument that there.
We've construed several provisions of the State Bar Act.
Yeah, but there's moral turpitude, there is 61.
Well, we've actually opined on this.
I know, but you're saying, the way I read that is that it affirmatively says. It's implying to me, the way that's worded, the State Bar Act affirmatively permits. And
Permits, that's what we said.
see, I love you, and I know what you're doing, but I just think, I think we should be really careful.
Okay, that's fine.
Based on the, what we're doing is trying to clarify a concern, identify.
Okay, I'm happy to take
I'm
it out
worried
if you
that,
think that.
I don't want to open us to any more slings and arrows.
Got it. Fair enough.
If you wanted to be narrow, you could say, under Rule of Professional Conduct 1.2.1, comment 6, I, Laura, may ethically advise, but that's.
No, I think if I can't have the whole hog.
I understand you do make that argument throughout, but I'm not sure it affirmatively states.
No, I'm with you. I think it's fine. Why don't we take it all out? Maybe just go back to a lawyer.
Yeah. Toby, you had a comment? Or sorry?
No, don't take it all out. Leave in the rules of professional conduct. I think you don't lead with the negative. You lead with the positive of what it's about.
I think you're right.
I think it's really clear the way it is now.
I think under the rules of professional conduct is a nice way to do it. That's good. Okay, I'm okay with it. Andrew, you okay with that?
Yeah, I mean, that's more supportive.
All right, and so unless there's more, it feels to me like I'm gonna sit down with Justin, if you're interested, and others, to think about how we might further wordsmith the scope section, and then we would bring this back after lunch. And if we like it, we can then see if we want to vote it out.
Sounds good. Anyone have any comments?
Thank you. And now we're on to, oh my goodness, I'm up again. Vulnerable client. So this is a down payment on a real draft of a more comprehensive opinion. I don't yet know enough to write a more comprehensive one, but I'm hoping to learn a lot by preparing with my panel, who do know more about it than I do, about how to think about other kinds of questions. But in the meantime, because of some work that I was doing for Marshall on his opinion on advanced waivers, I got to a place where I felt I could write the advanced waiver part of 13002 opinion. The background here and the reason that this comes to mind is that the proposed Rule 1.14 as submitted to the Supreme Court contained language authorizing such an advance waiver. Right? Now, we have no idea exactly why the California Supreme Court rejected Rule 1.14, and one of the premises of this opinion which isn't laid out yet, is that rejections, that the California Supreme Court's rejection of 1.14 can't be read as rejecting other concepts in the rule, any of the concepts in the rule, if they're otherwise supported by existing California law. Right? So this is the effort to examine whether the kind of advanced consent in 1.14 is supported by California law as it exists without 1.14. That's the background. The claim, and I'm just going to summarize it extremely briefly, is that advanced consents with respect to confidentiality are recognized in our opinion 1989-115, which is probably one of the pioneering opinions in the country on advanced consents generally, and also recognized in the Maxwell case from the California Supreme Court, which I think it was your comment, Brandon, that pushed me in the direction of thinking about the Maxwell case. And we also have a lot of material on advanced consents in the conflict area, which the gist of which is that if it's specific, right, reasonably specific, it's likely to be enforced, at least against a sophisticated client. Then we have this, there are a couple of questions that, so the argument here is yes, you can do this. You can consent if the consent is limited to a situation where it's clear that you would benefit from having your lawyer make the disclosure, and if those circumstances are sufficiently limited so that you can understand what's going on. There are some counter arguments that aren't in here. One is, what's the client's right to revoke? The assumption here is that the client would have the right to revoke except when they lost the capacity to do so, right? In which case, of course, the lawyer's intervention might be thought to be particularly desirable and beneficial. The other question is, does the lawyer have to go back and review this, right? There's some concept in the law of advanced consent, particularly in the context of conflict waivers, that you might have to get a second approval if circumstances differ materially. I don't think that concept applies here, because the conception is if disaster strikes, right, the lawyer should be free to make the disclosure, right? And so long as the lawyer is confident or can make a reasonable professional judgment that disaster is striking, right, they ought to be free to do what the client has authorized them to do without having to check back with the client. Anyway, otherwise it's not quite clear what an advanced consent would be in a sense. Anyway, that's the background. What are people's thoughts?
Steve, I actually have a question. It's kind of a broader question, I guess. So right before the discussion section, the last sentence in the fact pattern says, the lawyer wants to know whether such a consent to such protected disclosures would be valid. And my question is, does that make it seem like the opinion is about the validity of the consent? Because the real question is whether a lawyer can act in reliance of an advanced consent.
I think
right?
that valid is that sentence is not adequate, right? It's whether what a consent would be valid and whether, acting on the basis of such a consent would subject them to professional discipline.
Right, whether you can ethically.
Right, so I think clarify.
Whether it's ethically proper to.
Ethically proper.
To do that. I don't know if we want to say subject, I think we avoid subject to discipline, right?
Got it, right. But ethically proper. I think that's absolutely right.
I think it's a really, I'm sorry, you have
No.
I thought it was really interesting. I thought it was a really good discussion and analysis. I think the questions that I just sort of had raised were mostly on page 4. One is just the final sentence on lines 160, 161, where, as you articulated earlier, that the concept is that the client can revoke it, as long as they retain the capacity to do so. And then that raised questions for me about like, well, how will the lawyer judge capacity? And, you know,
There's gonna be a lot more about that in the opinion.
right, and so that's a question I have sort of in like what, you know, and having that be sort of the litmus test, and I think that goes to the specific language regarding the advanced waiver and the consent to it and how that would be framed, and I think to the extent that, I mean, you kind of outlined like what that would look like, and
That's
as the-
stolen completely from the
yes,
rule.
yeah, okay, so it's just the idea that like, at what point, because I think that would be a big question I would have, at what point would the lawyer, you know, how would they judge that, and should we suggest some way that they would be able to do that, or what are we gonna say about that? I'm not suggesting a solution, but I have that question.
I think it's a really good point, and one of the things that we're gonna have to say, in order for this opinion to be useful for people, we're gonna have to do, as Rule 1.14 did, we're gonna have to say something about capacity.
Yeah.
We're gonna have to say what it is, we're gonna have to say how the law defines it, right? We're not gonna go into detail, but we're gonna have to at least give a sketch of that set of questions. We're not gonna be able to resolve all the issues that are involved in the case law, because the case law is, frankly, there's not very much of it, and it's very far from definitive. So we're just gonna be able to identify a sort of a set of the issues, right? And I think we're gonna be also probably identifying ways more generally to, how should I put it, to take the capacity determination out of the hands of the lawyer in certain circumstances, right? I mean, there are ways to do that, and I think it was Kendra, you raised that very early on, the idea that you might actually have some specified event that, like the opinion of a certain expert whose view would be conclusive, and the law clearly allows for that. This is a little different because the assumption is that the client is willing to rely on the lawyer's judgment, right? But, and that doesn't seem to me an unreasonable thing to do.
Yeah,
but
I mean,
the
I just
lawyer
think-
may not want to have that burden.
Yeah, and I would be, obviously, like, I think it would be concerning and problematic and difficult to navigate a situation in which your client was saying, I want to revoke that consent specifically,
Right.
and then you thought they didn't have the capacity to do so. So it's like, and you're sort of saying, well, I hear what the words that you're saying, but I don't agree that you're really in the situation that you have capacity to revoke that. That's a little problematic for me,
right,
conceptually, you get that, that would be the situation in which, like, again, they're telling you they want to revoke it. Not that they become incapacitated and then you decide to exercise your advance waiver and act accordingly, but on the revocation piece, I'm
Well, we may
concerned about that.
want to not go into as much detail in the revocation piece, but it's my point about capacity, adding that point about capacity to do so, that's an add on my part.
Yeah.
And it may complicate things more than we want to.
Yeah, and then the only other comment and I don't really have an answer to that, like, I really like this analysis and discussion, and it's like kind of the solution to this issue, or really like a helpful concept, and I'm just wondering, like, thinking about if it could be misused in other contexts with this idea of like an advance waiver related to confidentiality, and like, if we do it here, like, do we want to really be specific that this is a fact pattern in which it's okay to do it, but in a lot of other situations it wouldn't be okay to do it, and or maybe as a committee we think it's okay to do it generally, but I guess I was just sort of thinking about, like, is there ways in which this could be misused, where you have fee agreements where people are like having clients sign away like, oh, in the future I can disclose all your confidential information, you agree to let me do it, great, it's an advance waiver, and then what does that mean, and does a client, you know, understand that, and in what context, and like, I just want to be mindful of that end of it.
I completely agree, and it seems to me that it would be easy to add another paragraph that sort of draws out some of the lessons of the Maxwell case. You know, the court says, yeah, you can advance consent, but then it strikes down, in substance, it ends up striking down most of the advance consent on the ground that it's overbroad, or it involves derelictions. It authorizes the lawyer to do something that violates their duty of competence and loyalty, right, in an ongoing matter, and so forth. And I think that we could easily highlight those limitations even more than the current draft does.
Yeah, I think we need.
Because I think it's important that this is a very focused consent on a very specific situation with with a clear benefit to the client, right? And my guess is that those are the kinds of situations we mostly want to limit advanced consents to, at least advanced consents within the context of an ongoing representation.
Yeah. So I would want it. Yeah, I think that needs to be.
Yeah.
Clear. Those are my comments.
Yeah.
So, it's a minor point, but sort of along the same lines. I'm looking at line 137 and 138. And we've had a discussion right before that about certain authorities, and we say that these authorities demonstrate that the proposed advanced consent should be enforceable, provided, blah, blah, blah. And I'm just thinking from a wordsmithing perspective as this opinion gets refined, my personal view, and others might disagree, is if we could stay away from reaching kind of the sort of legal conclusion of enforceability, I think there are ways to say this in a way that doesn't compel us to reach legal conclusions. And I think that relates to what we've been discussing, which is to highlight that the particular advanced consent being described in this opinion is consistent with law, or is ethically appropriate for reason A, B, and C. I think that just is a more nuanced way to describe what we're trying to convey, as opposed to.
I think that's absolutely right, and it's consistent with what Amber was saying. Right?
Yeah, and it's promoting the client's interest as opposed to like another way it could be misused, which would maybe benefit the attorney or something.
I fully recognize this is, draft, but that word enforceability or enforceable stood out to me, so I just wanted to flag.
I think you're absolutely right. That's not where we want to go. We want to go with ethical. Right?
Yeah.
That's it.
Further comments? Does our Orange County office have anything to say?
No, I think this is Brandon. I actually think this is a great and fascinating first draft. I am very concerned about the potential for mischief, as we just discussed, and the lawyer's creativity in applying that mischief or constructing it. But I do think this is an extremely helpful thing, a helpful opinion for the probate bar, because I hear them talking about this all the time. I wonder if there's anything to be made of, clients can, in the probate context especially, create irrevocable trusts that cannot be revisited. And I wonder if, as part and parcel of any such trust document, we've seen trust documents where the client/trustee is the initial trustee until such time as they may be incompetent to do so. I wonder if things could be built in there as well, and that might be much too substantive and less substantive legal analysis rather than ethical analysis. But it is something that your admirable draft here made me think about.
Well, I think it's absolutely right to think about that. There will have to be some discussion, right, when we get to the question of other planning techniques, right? There's going to have to be discussion of these various types of what I would call estate planning / power of attorney documents, right, that can be used in this setting as well, right? So that this will not stand as the only way that these risks can be addressed, right? And I think that the irrevocable trust is one notion, and power of attorney is another. And there are, as you know, probably there are both durable powers of attorney and springing powers of attorney. And we're going to want to make sure that those are featured, although we won't be opining on them. We'll be at least identifying them as tools.
Okay, I agree with all the How do I do this? I agree with all the prior comments. I have to say, but I do want to say that this, I don't want to be a naysayer because I think that we need something like this, but it makes me a little queasy. And it feels at the moment in the language a little bit paternalistic to me. And maybe that's the nature of the discussion. But if the way that it's written now is the way that it sounds at the end, it makes me wonder what a lawyer who works primarily with individuals with disabilities or incapacities would make of this. I'm talking totally, I mean, it feels like there's a big assumption of goodwill and good intention on the part of the lawyer, and there should be. But I'm not getting enough protection, feeling enough of the protective aspects for the client. And it might be worthwhile to get some input from lawyers or others who have actually been in a space of being named in advance with power of attorney, and how in real life this works as we're writing this. I just think you have to be careful, and it might be worthwhile to get some of that kind of input in advance so that the product at the end is sensitive and has that kind of, is informed, is really well informed from a number of areas.
Those comments are very well taken, all of them. And I think that my intention is to actually run these ideas by a bunch of people who do this kind of work, and not just people who do this work from a particular angle. Two of my panelists on the panel that we're doing at the symposium, one of them is a leading sort of figure in the States and Trust Bar's view of this. Another is a leading elder law lawyer, and they have somewhat different views, I think, on this question. And you're absolutely right, though. A lot depends on how meaningful in terms of paternalism. A lot depends. There's paternalism both ways, right? You could say exactly. You could be. So that's part of the trick here. Is that it might be paternalistic to say to a client, a competent client, you can't protect yourself in this way, right? But it might be paternalistic to say to a client who objects later on and says, I want to take it back. It might be paternalistic to say you can't revoke because I don't believe in your capacity. So there's those risks are all through it, and you're absolutely right to identify them.
Yeah, and I was also going to point out at our last Bar Association of San Francisco Legal Ethics Committee, our ethics committee was asked to re-examine a much older opinion that was issued in 1999 on this same issue, in light of the fact that the Rule 1.14 wasn't adopted in California, and someone who's the chair of the Trust and Estates Committee for the Bar Association had provided that comment and also gave us a pretty extensive article from the Trust and Estates section. So I can forward that article. It might be useful.
It would be very useful.
In some way.
That would be very useful.
And I'm sure she would be open to speaking with you too.
By the way, when we get to that part of the opinion, it's clear that that's San Francisco Bar opinion, right? It's pretty clear to me that it was no longer good law even before 1.14, and it's certainly not good law now. But it is not an advanced consent case. It's an implied consent case, right? It's a case where the San Francisco Bar Association said the lawyer doesn't have to have any approval from the client. They can simply do it because of their implied authority to protect the client's interests. And I think that the premise of 1.14 is that that kind of implied authority, and of this opinion, is that that kind of implied authority does not exist in California.
Yeah, my only comment on this is, you know, I know that the focus is on this advance waiver, but I think, and maybe this is in line with what Toby was saying, there's nothing in here that talks about when that authority kicks in. When do you know that this client has the diminished capacity, and who gets to assess that?
Or when can you make a reasonable judgment? Because
Right.
that's what it actually says.
Right, when and how. And I think that's kind of the missing piece here, and whether or not we can dive into that as a committee or not is something we need to think about. But yeah, that's where the abuse will happen for sure. And is that something that has to be worked out between the competent client and the attorney in the advance waiver? Do those terms have to be put in the advance waiver? Or
Right, well, certainly the lawyer is better protected if they are, right? And that's, I think that was part of what Dina was saying too.
Right.
I do think that we will not be able to make a judgment on whether we think this is a sensible approach until we see it. We won't be able to fully make that judgment until we see it in the context of the entire opinion, right? We're going to have a bunch of stuff that says no implied authority to disclose. We're going to have a bunch of stuff that shows that there are often going to be situations where your client is incapacitated, where you're essentially powerless to help them, right? Because they can't make any decisions to authorize you to do anything, and you can't make any disclosures. And so it's going to be against that background, right, that we're going to be considering this. And obviously part of it is going to be this question of how would a lawyer want to take this responsibility on, right? And how would they exercise it, right, if they had it? And it may be, in the end of the day, that we'll conclude this is a bridge too far. But since it's part of something I thought we ought to be considering, I put it out there for initial discussion. Hopefully I'll have a lot more stuff by our next meeting. Questions, comments? That was exceptionally helpful and raised all the sort of questions that I've been hoping people would raise that are sort of not in the opinion but are essential to understanding whether it's correct. Okay.
Do you want to do live since it's here?
Pardon?
Do you want to do live since it's here, or do we want to?
Do you want to break for lunch or what do you think? We have, I tentatively set improper contract provisions for 12 to 12:30, but we could perfectly well break between, we could perfectly well break till 12:45 and then do improper contract provisions right after that. How do people feel? People ready for lunch?
Yeah, that sounds like a good plan.
Okay, so we'll come back here. We'll come back then at 12:45, and David will do improper contract provisions at that point.
Okay.
Great, thanks.
Thank you.
Okay, So we're back, and we're back, and we're going to go back to 17001. Over the lunch break, Justin and I looked at the scope language to see if we could tweak it, and we only came up with a couple of small tweaks, which are reflected in the passage that Mimi has on the screen right now. Essentially what we did is we moved the limitation to California up, right? And we think that that makes it a little clearer. Not that it needed to be that much clearer, but it makes it a little clearer because then we go on and say the opinion does not address these federal criminal law issues, and then you go immediately to language which says this is not binding on state bar discipline authorities and federal law enforcement authorities. That's a pretty clear caveat emptor to anyone who's actually reading that we're not providing any comfort on that issue. And then, of course, we are explicit about that several times later in the opinion, one way or another. So that's all we did because we couldn't really figure out what else to do that wouldn't beyond what we've already done. So that's the change, and with that change, I guess the question is whether somebody wants to move that this opinion be sent to the Board of Trustees for its review.
Does anyone have any comments about these changes, these minor changes?
Yeah.
Yeah, I would move that we vote it out for consideration by the Board of Trustees. Does someone want to second that?
I'll second.
Skylar Ross, UCLA School of Law.
Has joined the conference.
Hello, who is our guest?
Hi, Skylar Ross. I'm a student at UCLA School of Law.
Oh, great. Mr. Roth, we're just about to vote on an opinion, so you come at a moment where we'll just be giving our yays or nays.
Sounds great, thank you.
So, the motion is to vote the opinion out for public comment?
No.
To the Board of Trustees. Oh, to the Board of Trustees, okay. As revised. Stephen Bundy,
Yes.
Ken Bacon, Sarah Vanola,
Yes.
Kendra Basner,
Yes.
David Carr,
Yes.
Justin Fields,
Yes.
Toby Inlander,
Yes.
Adam Koss,
Yes.
Brendan Krueger,
Yes.
Amber Lee,
Yes.
Dina Roche,
Yes.
Marsha Lee. Thank you.
Okay. And now, I think we're on to, David, we're on to your topic.
Okay, great, thanks.
On lawful contract provisions.
Thank you, and I've submitted an updated issue memorandum reflecting Sarah's comments, which I thought were extremely good and very timely. I'll just mention some of the topics, and Sarah, you can chime in if you have additional comments. I like the change that she suggests that we address the scenario where the lawyer is updating a contract that has a provision that may have subsequently be found unconscionable. So I think that could be a good addition to the hypothetical. Under item 2, D2, let's see, where are we in the outline? I guess, yeah, D2. I agree that I think we have to proceed. We can't be in the business of weighing what provisions are unconscionable or not unconscionable. So we have to, as a basic assumption for the opinion, assume that this is a provision that has unambiguously been found to be unconscionable. And I realize there may be some play in that concept on certain provisions under certain circumstances, But I think I agree that weighing in on whether those provisions are unconscionable or not is not part of what the opinion is. It seems to me, and maybe I'm optimistic, that the analysis is pretty straightforward until we get to the point, now we're at revised outline 6 with Sarah's comment regarding the client insisting on including an illegal or unconscionable provision. Up until this point, I'm guessing there's a broad consensus that a lawyer may not recommend or advise the use of a provision the lawyer knows to be substantively unconscionable. The question in my mind is what happens if the lawyer has discharged that duty, and we've gotten to the point where the lawyer has said to the client, and perhaps I'm thinking of some of my own experiences here, you can't do that. You can't have this provision in the contract because it is unconscionable. I advise against this. And the question in my mind is what happens if the client doesn't take that advice? What happens if the client says, thank you, Mr. Lawyer, I appreciate your opinion, but we want that in our contract and we're going to put it in regardless of what you say. I guess the question of what remedy, if any, exists at that point, or what the lawyer should do in response to the client's unwillingness to take the lawyer's advice. This is where I start to, I think, have some uncertainty about where the opinion might go. And this is consistent with, I think, some of the comments we heard in the public comment period about what does the lawyer do. I think it's not clear to me. It's not clear the lawyer at this point has a duty to withdraw or not. But obviously we have to explore whether that is part of what the lawyer has to do. The part about advising seems pretty clear. The question is, what happens if the lawyer's advice is not taken? What must the lawyer then do? It's not at all clear to me. The rule on termination of employment, withdrawal doesn't appear to compel, at least as currently written, compel the lawyer to withdraw unless the lawyer's continued employment will lead to a violation of the rules of professional conduct, and I'm not sure whether it does at this point. And this kind of ties into what is revised outline point 9, applicability of other rules and state bar provisions, truthfulness in statements to others, 8.4, dishonesty or conduct that impugns the integrity of justice, moral turpitude, duty to support the law. And I'm not real certain of the answers at this point, but I think we have to address the question of what happens if the client decides they're not going to take the lawyer's advice. To what extent, again, goes to the gatekeeper idea. To what extent is the lawyer the gatekeeper for the client's conduct? And I think this is the part where I'm not at all clear of what the answer is. And any comments on that?
This is Brandon. I do have one question as to whether we believe it makes any difference, the obligations to the attorney in the hypothetical, does it make any difference if the other party to whom the contract will be presented is represented by counsel? And as should be clear by my silence there, I haven't thought that through. I'm just very curious.
Well, this kind of goes to the nature of the non-compete agreement, the non-compete clauses, because my understanding in the original problem posited to us was that these were the type of provisions normally that would be included in an adhesive contract presented to an employee who in all likelihood would not be represented by other counsel. And I guess Brandon's question is, well, would the fact that that the other side has counsel available to them, and it kind of goes to my original question about unequal bargaining power, if there's no disparity in bargaining power, does that change the lawyer's duty with respect to an unconscionable contract provision? I don't think it should, or I don't think it does or should. But obviously, we're looking at I think in at least one scenario where it's pretty clear the putative employee is not going to be represented by a lawyer at the contracting stage, or maybe even down the road.
What's hard is that unconscionability is a concept that does depend sometimes. So it a little bit depends on how you've written. You say the lawyer knows it's unconscionable, and that would presumably have to mean that they know it's unconscionable, even if the other side is represented by counsel. Right.
Right. Well, that's why I think on that principle it shouldn't make a difference.
Right. I agree with that. One other thought on this is that the rule we're construing here talks about more than just it talks about illegality, right? A violation of law. And whether we want to pin it on unconscionability, which has this, or whether we simply want to say violation of law, right, which might include unconscionability, that might be a cleaner way to do it.
Well, I like that formulation because I would like to try to write something that is, I think, broader in application than just the narrow situation where an employee is presented with an adhesive provision that's unconscionable. I really think the opinion is stronger if we go a little bit broader. So I think that's item 4, and Sarah's noted that too in her revisions, that an illegal or unconscionable provision under 1.2b1, which, and I think it's pretty clear from the way the rule is written that that's broader than something that is criminal or fraudulent.
Right.
Violates any law, including a ruling of a court. So I agree. I think that is the way it should be written.
So, sorry to interrupt, just really quickly, where are we getting the unconscionability standard for part of this analysis?
I'm sorry, how do we know it's unconscionable?
No, from what authority are we pulling the term unconscionable for part of this analysis?
Well, the contract provision would have to have been subject to either a statute, and I believe there are statutes in the B&P Code in California regarding non-compete agreements. I think there was an email from Richard Zitron that I saw distributed that suggested another possible provision that might be illegal or unconscionable. Obviously, a predicate would have to be, there has to be a statute or a case or some authority that holds that the provision is unambiguously illegal or unconscionable. I think that's the premise we're starting from.
Okay, I mean, I know there's unconscionability in 1.5.
That's like a legal standard, right?
Yeah.
And not necessarily an ethical standard.
Right, and that's fine if that's what we want to incorporate, but we should set the predicate for that as to how we're using that as our standard.
David, I had one more comment. This is Steve. I have one more comment, and then I want to get out of this. But my own instinct is that it's very important to specify what it means to know that something is. I mean, that's the part of the rule that matters, right? We could almost pick a hypothetical, right, in some sense, right? We have a rule-based definition of what it means to know something, but what does that mean in the context of a proposition of law, right? And I don't know how deeply we can go with this, but it's a little bit like the question of when is an argument frivolous, right? And so to my mind, I think Sarah's absolutely right that we don't want to get into the business of opining whether any particular California substantive law issue triggers this. But as an ethical matter, we might want to say, if you have some hypothetical law, right, when you know that conduct violates it, right, or that the law does not permit it, that's something that could merit at least some thought.
Well, I know that knowledge is a defined term under Rule 1.0.1.
Knowledge would mean that if you hadn't done your homework, right? You hadn't done your homework, you'd be in the clear, but if you did do your homework, you could be sunk.
Yeah, I'm looking at my paperback version of the rules, which strangely enough does not have the definitional section. Oh, here we go, here it is. 1.0.1F, knowingly known or known, I don't know how useful this is, means actual knowledge of the fact in question. A person's knowledge may be inferred from circumstances. This is not a very helpful definition for our purposes, I don't think.
I agree, but if we're going to say it seems to me we have to be willing to at least flesh it out a little bit.
Right.
Is the opinion premised on the idea that there is absolutely no question as to the legality or enforceability of whatever contractual provision that is at issue? That's presumed.
Yes, that's.
I think that's right.
So, I mean, that's the question I had around that too, which is like, are we've mentioned non-competes. Are we gonna is the word, I mean, the whole way this opinion came to us is through non-competes, right? Are we saying anything about non-competes? Or are we now gonna we're not gonna identify a provision at all, but say like, the attorney knows it's absolutely illegal? I'm confused about how that concept, are we gonna say the attorney has, there is this non-compete and they've reviewed it, and based on the language in that particular provision related to non-compete, they're sure that that's illegal and unconscionable, and then they're therefore like, I guess because I think that again, we're making our own decisions about this opinion and what makes sense, what we can do ethically, and what's the right thing. But like, obviously, it came to us with this idea that that's something that, was sort of the example premise of what the basis of the opinion, right? And are we going to be using that or not?
Well, that's how it was teed up to us in terms of a rather specific type of clause in a very specific California statute that addresses non-compete clauses. In some of our comments we had earlier suggested that perhaps the unconscionability question was not as clear as it might be depending on the location of the activity. Where the employee was located in terms of the effect of the non-compete clause. The impact might be different on an employee outside California, if I understood the comments correctly. So I don't know, to get into the issue, it seems to me we have to presume that there's an unambiguous statement of law that the provision in question is illegal or unconscionable. And if we start getting into the question of parsing that out, I don't know how we can write an opinion that has, I think, broader applicability.
Yeah, I agree with you, David. And the other question based on our discussion just now that I'm evaluating is, I almost prefer to just use the term illegal and not unconscionable in this opinion. Because I think unconscionable is a more difficult term to get into procedural or substantive unconscionability. I just think that's harder to say the lawyer knows it's unconscionable. I think it's easier to say the lawyer knows the provision is illegal. And that's just more clear cut. So I would prefer to just use the term illegal throughout.
I think that makes a lot of sense because obviously the rule's talking about something that's contrary to the law, even if it's not a crime or a fraud, but is illegal in some sense.
One other approach, it might make the analysis a little more difficult, but in terms of broader applicability or just general intellectual interest, is the concept of it being fraudulent. I think one of the examples was the lawyer knows that the agreement is unenforceable, not necessarily that's illegal, but based on his or her position of power is going to include it, maybe in the contract with the client, and the client just scare off the client from, I'm sure you've all seen some things that are pretty egregious. I don't know if that's fraudulent, raised to that level, but that's something that I hear from time to time that lawyers use I'm sorry, I don't have a great example off the top of my head, but something like, you must pay your fee, your outstanding bill to me in full within 60 days if you haven't made a payment prior to that. Something just egregious.
One-way attorney's fees clause in the contract.
If that's inappropriate.
Yeah. Well, Andrew, my instinct is to stay away from those issues. David is the author, but my instinct is to stay away from lawyer-client issues because there you've got a fiduciary, either it's at the beginning of the representation or it's a fiduciary relationship.
Sure.
If it's a fiduciary relationship, right, and you're purporting to still act in that relationship, you're going to have duties to disclose material information in your possession, and so you can get caught in a fraud claim very easily. Right, if you're doing that. But the situation we're talking about, I think, is a challenging one, which is the arm's length situation where you're counseling or maybe assisting, right? And I'm not meaning to suggest we shouldn't be interested in the other question. I think it's a very important one, but I think it merits its own opinion.
Yeah, no, you make good points. I wonder, and I'm not advocating strongly, but a client wishes to use a provision they know is unenforceable, not necessarily illegal, but the fraudulent aspect, if I take your point, not between the lawyer and his or her client, but the client is asking the lawyer to help the client use that provision for their own purposes with others. But maybe it's not interesting. I'm just sharing thoughts.
Well, there's sort of an interesting harmony with our opinion, with our cannabis opinion, which kind of, in a sense, talks about some similar issues.
Yes.
Yes. How do we parse out assisting or counseling versus assisting? Because there are clients who, of course, won't listen to what we say, and they're probably, and maybe I'm influenced by my brief experience as an in-house counsel, where nobody in the organization seemed terribly interested in what we had to say, even though that was our function. In fact, some people that have done in-house counsel gigs may perceive, as I perceive, that the other people in the organization tried to avoid us as much as possible because they didn't want to be told no. So, yeah, I don't know what the answer is.
David, that's why I think it's actually pretty important that maybe we can discuss the issue of whether under certain circumstances there's a duty to withdraw. I think it's very difficult to apply in the in-house counsel type situation. If you've provided the proper advice, but the client is still insisting on including this illegal provision, and whether Rule 1.16 mandates withdrawal under that circumstance. And the only, looking at the rule, you have to I think, conclude that it falls under subsection A2, that the lawyer knows or reasonably should know that their representation will result in a violation of these rules. I'm not clear under those facts whether withdrawal is mandatory, but I'd like to just get everyone's feedback on
Well, it's
there.
unfortunate that, like, yeah, subsection A1 is not, I mean, it's clearly like drafted with litigation in mind, right? And like,
Yes.
that's not the only context in which, so I mean, I feel like that analysis would be perfectly applicable here, except it doesn't actually like say that in that way where you can quote and say that it should apply, but I feels like it should, right? Because it's the concept of bringing conducting a defense or a position that is basically like meritless, or it's gonna be, and that's really like, I think the concept of the opinion is, except I don't know that, I don't know.
How about this? I mean, let's assume that you've done what the outline suggests you should do, which is to say this provision is unlawful and you can't put it in the agreement. They say, okay, I'm gonna put it in anyway. Isn't the answer, well, I'm sorry, I can't help you with that.
Yeah.
Right? That's not something I can have any involvement in, because that if I were drafting it or presenting it or negotiating it, then I would be assisting within the meaning of 1.2.1, and then I would trigger, right, B, as you were just, right? Now that's not much of an answer necessarily for the in-house counsel, right? I mean, but it does seem to me that's the way the rules read. Is that you then have to say, I can't be in this.
Yeah, I think that's.
Yeah, David, sorry.
Yeah, I think that's correct. Yeah, and I think Sarah's point is correct that I'm telling you, client, and the lawyer probably has an obligation to tell the client this provision is illegal. It shouldn't be in the contract. If you choose to use it, I can't defend it in a litigation context or some other context. But remember the sort of basic scenario, and this isn't like we're sitting down in a conference room negotiating a contract. This is an adhesive contract that some functionary in the HR department presumably is going to just give to an employee and say, take it or leave it. So it's not clear where the focus of the lawyer's action would be in that context, because the lawyer, generally speaking, in-house counsel is not going to be involved in day-to-day employment decisions at that level. At least that's my understanding.
Well, and just I wanted to raise one other thing that, I mean, which I've seen happen a lot, and I've seen a lot in contracts and stuff, and the very cynical view, which is like, these provisions will be put in place, and then with the caveat, like, to the extent permitted by law. I mean, I think we've all seen that in some of these things. And so then you have this situation where they're like, well, I mean, it could be like, if they tried to enforce it in like New Jersey, even though nobody would even have a basis for jurisdiction there, like this would apply. And I mean, obviously the point that, this was brought to us as this sort of like the chilling effect of these provisions, right? And I'm not saying that we can do more than we're already discussing here, because I completely recognize those limitations, but I just feel like I see that all the time. I've seen provisions in these, non-compete, non-solicitation, like where they just say like the thing they want to say, and then to the extent permitted by law, you can't do the following things. And then that's sort of the get out of jail free card. And not that I want to put that in this opinion, give people more ideas, but most people understand that drafting convention, and is that disingenuous to say that?
If it's not permitted by law in any foreseeable interpretation of the contract.
Well, somebody came up with
any
ideas
foreseeable series of events.
But there's someone, like there was the letter that said that, okay, and non-competes aren't always unlawful, and here's the circumstances in which they're not.
No, I totally get that.
And it's like, come on, I mean, if that's a legitimate thing, you could put the caveat saying, like, if you're gonna enforce this in this jurisdiction, blah, blah, blah.
Okay, here's one. This may be too far afield, and I offer it up very tentatively. But there is a concept called promissory fraud, where you make a promise that you have no intention of keeping, right? How about a provision that you have, in advance there's no legitimate basis for enforcing, right? And you put it in there as if there's some basis for enforcing. I don't know whether that concept helps But it does feel to me that's what we're trying to get at, is some sense that in fact it's not being included in good faith. It's only being included to terrorize.
Yeah, I mean, I think that there's a lot of value to what we're gonna try to do here. I just think from a practical level, there's never gonna be like a enforceability, disciplinary way to like really ever get someone to like be accountable for doing.
I'm totally with you, and I do think that this, I've always felt that in pressing for us to write this opinion, that, you know, if in an ideal world, you know, the people who've been pressing us to write this opinion are thinking this is really going to help. And the reality is that it may not help in most of the situations that they have in mind.
Yeah. I mean, maybe it will be enough to just say, you have to explain that this is not going to be enforceable or it's illegal, and if the client insists upon including the provision in the contract, then you may not take any part in making that happen. And perhaps that's enough, and that's all we can say, and maybe that advice is enough to cover in-house counsel too. Because if you're going to use non-compete provision as an example, as a key example, at least in my practice, I see the provision being included by the in-house department most of the time. They're not going to outside counsel and having a contract drawn out, right? So maybe that's it. Maybe that's all we can say, and it has to be enough.
Well, that's kind of where I think this is all going to come out to you know, that in fact the lawyer, as much as we might want the lawyer to be a guarantor of the client's conduct, in the real world that it can never absolutely happen. So there are some aspects of this opinion that may not be terribly practical.
To that end,
how would we ever know?
Right, and to that end, the point that you added, point number 9, the possibility of bringing in 4.1 and the moral turpitude issue, that would that make the question even more mushy, or somehow expand the scope of the attorney's duty in ways that's not going to be very clear to the reader?
Well, I don't know that, I mean, if it violates 1.2.1, it seems to me that's kind of the threshold issue. And if you advocate for a provision you know to be illegal, you violated 1.2.1, and maybe you've also violated 4.1, 8.4, and other provisions of the BMP code. So I'm not sure that these additional authorities really kind of go to the threshold issue, which is that under one, you know, if it's illegal under 1.2, it's probably illegal, it may be illegal under other sections. But we're talking about a situation where the lawyer knows and is recommending something that is unlawful. And that is not exactly, I think, what we're addressing here. We're addressing here situations where the lawyer says, I know it's illegal, I'm telling you you can't do it, and the client chooses to do it anyway. Is that sufficient proof that the lawyer has assisted the client's conduct? I don't think it is. And I don't know how you penetrate attorney-client privilege unless you can show crime, fraud. I know the argument's been made. How do you penetrate the communications between attorney and client to parse out the degree to which the lawyer tried to resist the illegal provision, or the lawyer just kind of rolled over and said, sure, whatever you want?
This is Brandon. Has this ever been litigated in the context of things like racially restrictive covenants and things that are indisputably outrageous and illegal, but that some people ask be included in documents? We know they're not enforceable, but is it illegal or actionable to even put them in a document? And could that extend beyond the party who asked for the provision all the way to the attorney?
I don't think, at least from the look in the room here, I don't think anyone knows the answer to your question, Brandon. But I did want to.
I agree.
Following up.
Well, that sounds like that might be a place to look to see if there's some guidance. If there is guidance there, maybe that's a place to look for it.
But following up on the other comment made by Amber, I think the way we have the different hypotheticals framed currently, I believe that we need to consider, if we're going to keep those hypotheticals, the potential application of Rule 8.4 or 4.1, because hypothetical is not limited to the fact where the lawyer advises the client not to use the contract with the illegal provision. Part A is where the lawyer advises HR to use the forms anyway, without any further advice or analysis. So I think in that hypothetical scenario, we should discuss the potential application of 8.4 C potentially, or the other Rule 4.1 of the relevant State Bar Act provisions.
And have you and David drawn any conclusions as to whether and how those provisions would apply?
No, we haven't had a chance to really consult on that issue. I think we need to follow up on that and evaluate it more.
In response to Brandon's question, the one area I know where there has been a good deal of writing, right? And on this kind of question is in the tax area.
Okay.
And, it used to be that there was a good deal of material in IRS Circular 230 on this. I haven't looked at it recently. But the question of when you're stating a position in a return, how strong a basis do you have for it, right? So forth and so on. And when can you assist a client? It might be helpful by analogy, even though it's not California law, right? It is a setting. It is a setting where the question has been thought about a fair amount.
Okay, I'll take a look at that.
I'm looking at standards with respect, this is section 1034 of IRS Circular 230, standards with respect to tax returns and documents and other papers. And it's a lengthy discussion if I think, what a legal advisor to somebody preparing a tax return can do.
Okay. So section 1034 of Circular 230?
That's what I'm looking at right now, and I'm not reading it closely enough to be confident that the concepts all apply by analogy, but I think some of them do.
Okay, well, I will look at that in more detail. But I think it's, Brandon's comment, it'd be nice if we could sort of get a toehold somewhere on this issue, because it seems like it should have been addressed somewhere at some time in terms of what the lawyers, to what extent the lawyer really is liable for assistance.
You might want to take a look at the annotations to ABA Model Rule 1.2.
Okay.
That's another possible source for this. And of course, the restatement is another.
Okay. And do we have access to the annotated ABA rules through staff, Andrew?
Yeah, I think we have one book in our office. Sarah may have mentioned.
I was gonna offer, I could look that up too, I've got it in my office, David, I could look at the annotations.
Oh, okay. I don't have the annotated ABA standards or something like BNA maybe.
Yeah, I have both.
If people have,
I can
you
look
have access to that resource.
I do, and the restatement too, so I can look at those three sources.
Okay.
All right. Has anyone here got anything more that they would like to add for David's and Sarah's benefit before we move forward? I thought that was a really good discussion. I guess one question to think about is, do we think we're committed, do we want to turn this into an opinion? In the sense of, do we want to, Andrew, is there a sort of a protocol for that? When do we move from writing memos about a prospective opinion to turn it into actually doing an opinion?
Well, there's no specific protocol. I do appreciate you asking, because obviously we've received public comment more than once on this topic. Just my own personal observation, it seems we're getting closer to having crossed that threshold. My own personal observation, I'm not sure we're there yet. It looks like we're doing a little more research to see if there is the quote-unquote toehold, or exactly how to frame this issue and what authorities to analyze. I don't think you need to commit yourself at this stage. Hopefully the next meeting, after some of this additional research is conducted, there'll be a better sense of the group in terms of confidence in moving forward. But I'm willing to be, David and Sarah have dug the most deep into this, so I would like, I should welcome their input to see what their views are in terms of the ability to make a formal opinion.
David and Sarah, is that approach okay with you, to leave it open and then we can have a sense of it?
Yeah, I think that's fine. My own opinion is that I think this could be an opinion and a worthwhile opinion, because I think it's a genuine problem. The question is how to frame the analysis in a way that's consistent and helpful, because I will tell you from my own experience counseling lawyers on fee agreements, I've had many discussions in terms of provisions my clients want to include that I know are not, under the substantive professional responsibility law, are not conscionable, if you will, or illegal, to use Sarah's formulation, because they violate one or more rules of professional conduct.
And the benefit of the way we're framing the opinion is that this opinion would actually give you some leverage in those conversations, right?
Yeah, it absolutely would.
Because it's an arm's length negotiation with an unrepresented party who's also at a disadvantage in informational terms. Yeah. Okay.
Well, and attorney-client fee agreements. That's typically doesn't get much more one-sided than that. Typically,
right.
Very few clients bring their own lawyer to the negotiation with the lawyer.
Right. This makes okay. So, Sarah, are you okay with leaving it open in effect as to whether this is an official opinion or whatever until next meeting?
Yes, I'm fine with that approach.
Okay, we're good then, I guess.
Yeah, I think it usually happens pretty organically, where the outline turns into more full-fledged.
Okay. So that's that, and then I'm just looking for my outline here. What I have next is the arbitration advisory on interest. Ken could not be here today.
Has left the conference.
Ken could not be here today, and so we are, but he was fine with having the discussion go forward, and Brandon, you've been working very closely with him on these arbitration advisories, and so we're counting on you to be his scribe in terms of keeping track.
I will do my very best. Yeah, Ken is far more knowledgeable than I am on these topics, but I will try.
Okay, well, that's all we can ask.
Has left the conference.
Okay, so Brandon, do you want to talk a little bit about the interest advisory? And what issues you think remain, if any?
Yes. So arbitration advisories, we've talked about a couple times since Ken and I joined the committee, are typically very different from a standard COPRAC opinion. They are used by the arbitrators, the volunteer arbitrators who arbitrate mandatory fee arbitration disputes. And it helps guide arbitrators through various tricky areas in determining their award. And one of the questions arbitrators typically have is whether and under what circumstances they can award interest. They can include interest and prejudgment interest in their award. And this advisory is simply intended to address that subject. It was, I guess, a work in progress at the time that the MFA committee evaporated and moved over to us. And Stephen Bundy had a lot of great insights, questions for things that hadn't been considered previously.
Has left the conference.
And we tried to answer Stephen's questions and update some of our citations to more current law. I don't think we have too many open questions right now. There's a question we have dodged here because I don't know the answer under substantive law, and I think it might be too detailed for what we're looking to get into. But the question we're dodging, it has to do with whether if some portion of an award of fees an attorney is seeking is readily ascertainable and therefore subject to pre-judgment interest, but some portion is not, do you effectively split the baby and get prejudgment interest for part of it but not the other part? Or does that mean that the whole amount sought was actually disputed? And I just do not know the answer to that. I haven't dug deeply enough into it. And that's a little more detailed than we usually get into in an arbitration advisory, though it is a very interesting question. I don't know if I've addressed the outstanding issues, but that's the one that leaps to mind.
Right.
I just had a question about generally, about whether we, and I think we probably should, come up with some kind of introduction to these things that we're comfortable with, about the fact that, this is, since now the advisories are under the COPRAC, that this is an arbitration advisory. It's not an ethics opinion, although it may touch on ethics issues, but really making sure that it's clear because, this intro is saying, it's not endorsed by the Board of Trustees. My understanding is that the Board of Trustees will look at it and vote on these. So maybe we can propose some kind of language about how we're comfortable, because obviously we don't ever typically opine on issues of substantive law, and there's some here, and I want to make clear that we're making the reader aware of what the limitations of the advisory are, and that they're not the same thing as an ethics opinion and that kind of stuff.
I completely agree with you. That's the biggest single question I have about what to do here. I want to, Andrew, can I ask a question about this? Do you think that in merging do you think that the board has really thought about this? Right? Because it doesn't strike me that it's one thing to say, take on the work, right? It's another thing to say, and we want to handle it exactly the same way as we handle ethics opinions. When we're handling ethics opinions, we're giving an opinion on something that the bar has expertise on. And one of the reasons we're all on this committee is because we have some expertise in it too, right? We don't have special expertise, and the bar does not have special expertise in questions like how does the law of interest work, right? And is that something the Board of Trustees wants to get into the business of reviewing something that doesn't have to do with the ethics rules, but is just an issue of law? Do they want to get in the position of voting on those when historically they have not voted on them in the past? And you may not know the answer, but I'm just putting the question.
This is Brandon. May May I facetiously suggest that COPRAC issue an opinion suggesting that the MFA committee be reconstituted? Because I just don't know how this works for our mandate.
So I think the idea was, as I think we're all aware, the committee has assumed 2 persons with mandatory fee arbitration background and experience. And so the issuing of an arbitration advisory was previously done by a full committee of folks who had that experience. So I don't think that there's any expectation that however arbitration advisories were administered previously can't be administered in the same way.
Well, then that would mean we aren't going to send this to the board for approval, since that's the way that it's worked in the past. I mean, I'm just saying it's an open question, right, about whether we, I'm happy if they want to say that when we're sitting as wearing our arbitration advisory hat, we can give opinions as to questions of law. There's still an issue as to whether we want to distinguish them from ethics opinions and whether they should go through the board.
This is David. Question, in the past, were the arbitration advisories approved by the board or just issued by MFAA?
Just issued by the Mandatory Fee Arbitration Committee.
Is this something that where we could actually ask the Board of Trustees how they'd like to handle it? With a little brief memorandum that sort of says, here are the issues as we see it, right? How do you want to handle it?
Yeah, you can. I mean, you can submit the question through staff. I can't promise that I can get it to the Board of Trustees, but I can.
Well, you can at least get somebody like Randy thinking about it, right? And then they'll have an idea
to address it. I mean, so again, arbitration advisories have been administered for many years now. I wish Ken was here; he might be able to speak more affirmatively on some of these issues. The change is, yes, for broader purposes of oversight, they want arbitration advisories to go out for public comment. There are disclaimers on arbitration advisories. They can, as you are alluding to, they can't make law. If there's an issue here that the group is unsure of as to what the answer is, it could either be worded in a way to make clear it's not sure, we're not sure what the answer is. On the one hand, there's this. On the other hand, there's that. Please proceed carefully. Or it might just be more prudent not to opine on an issue that we're not comfortable opining on because we don't know what the answer is. But in terms of the ability of this committee to issue arbitration advisories, I'm not sure that's going to get very far.
I'm not concerned about that. Okay. I assume we have the right to issue.
Exactly.
The question is, does the board want to review them substantively before we issue them?
No, it goes out for public comment, and then they'll be administered just like ethics opinions are administered.
That's what I'm saying. Does the Board of Trustees want to vote on questions of state contract law?
I don't think, again, the opinions don't, as our opinions, they don't go out as issues of they're not issued by the Board of Trustees. The Board of Trustees will review the procedural steps that the committee has taken. It's going to have public comment. We've reviewed all the public comments.
Oh, so it's accurate to say that our opinions aren't adopted or endorsed by the state board?
Exactly.
I didn't realize that.
Oh, I'm sorry. Yeah, each ethics opinion has a disclaimer. They are issued only by the Committee on Professional Responsibility and Conduct. They're not binding on the Board of Trustees, not binding on State Bar Court, or any other tribunal that administers, or any other tribunal, I think. So that it's always.
Do we think the idea of the disclaimer that was, I think, is a fabulous idea? Should it go so far as to say something like, while COPRAC normally does not opine on issues of substantive law, the purpose of the arbitration advisory is such that it is necessary? Or, I mean, do we want to be that specific? Because this is really different from an ethics opinion. And I just wouldn't want people to try to use it because it comes from COPRAC, to try to use it the way they use ethics opinions.
I understand what you're saying, Brandon.
Right.
I'd have to review. Yeah. I mean, maybe we can consider what the disclaimer is on the arbitration advisory now going forward. My only hesitation to the way you framed the disclaimer was it was worded as what COPRAC normally does or doesn't do. I would be more inclined to say arbitration advisories do X, ethics opinions.
No,
I think that's a great idea. I agree.
We can look at that. Staff can look at that.
The disclaimer our disclaimer is a little different for our ethics opinions.
Yes.
It does not say, and Dina pointed this out, it does not say they have not been adopted or endorsed by the state trustees. Right? They say they're not binding on them, but they do not say. I mean, I think there's a procedural step here that's different, right, for our opinions historically, because they have been adopted, or at least approved in some sense.
Approved for publication. Yeah.
Approved for publication. That's not true of the arbitration advisories, right?
Not previously, correct?
No, right.
So maybe all this points to the arbitration advisories do need a similar disclaimer, because there will be a different process for them now.
I'm still not clear. So arbitration advisory opinions will be submitted to the board for a review and approval?
Correct. They'll both go out for public comment, as an ethics opinion does. And then, well, the other thing is it doesn't go to the full board, it just goes to RAD, the subcommittee of the board on regulation and discipline. So that's another distinction. The board does not approve publication, only a sub-entity of the board does, subcommittee. And so, yes, following the review of all the separation of the bar to just be a regulatory entity, all the committees work with all the existing committees at that time were evaluated, and arbitration advisories were deemed to be important work to continue, and that because this committee is a drafting committee, and the fact that we draft ethics opinions would be rightly suited to be able to write arbitration advisories. We're bringing on people with arbitration experience to help lead that effort, and they will go through the same process as ethics opinions.
Could we say, would it just make sense to say that Brandon and Ken, working with you, should develop a form of disclaimer that works for this? And
yeah, I mean, I can get someone to look at it for sure. I mean,
right.
You raise a good point. I mean, the disclaimers that exist on the previous arbitration advisors probably aren't going to work for this. I don't know if the disclaimer that works for ethics opinions will work either, but we'll definitely.
It needs a more textured approach.
Take a look at that.
Yeah, and I think it should say something like, because it's going to be issued by this committee, that it should say something that this is not an ethics opinion, making clear that that's different, right? I mean, I think there might be some confusion because we're issuing this opinion even though it's like, I mean, it's not like we've kept the MFA intact, but it's like within our committee, it's like, it's been disbanded. There are members here we've been tasked with addressing those advisories, and I just think it should be clear. People might say, oh, COBRAC issued this opinion, that it's not an ethics opinion, you know, like,
sure, right? And they won't reside together on the State Board's website, so hopefully that will mitigate any confusion or misunderstanding.
Right, right.
But your points are well taken. I mean, all right. I just want to make sure we're all on the same page. A revised disclaimer will address, I don't want to say all, most of the concerns that you're talking about right now. Is that fair to say? The next, depending on what the disclaimer says.
This is Brandon. I think so. I think so. I can't think of anything better we can do.
Right.
Okay.
That sounds good.
Okay.
So on the substance, Brandon, let me say a few things. First, I think it's fine to drop the question of whether a portion of the bill can be viewed as undisputed, right, in a way that would trigger interest even though a portion of the bill is disputed, right? I do see provisions in retention agreements where people say things like, if you have a disagreement as to the bill, you pay the portion that's undisputed and you can only withhold the other part. but I don't think it's worth getting into in this case. And that would mean that, so just looking at the clean version of the draft, I think that the comment at lines 41 and 42 about the restatement can come out now. I think that the question that I put at 70-71 about disputed portion and undisputed portion can come out now. At 85, I think the first paragraph on 85 only applies to client claims, since the lawyer can't make a claim for interest unless the agreement provides it. So it's I wonder if you want to lead with when the client claims interest, comma, and there is no written agreement which specifies a rate of interest, right? Then the arbitrators should award or something like that.
Right.
Doesn't that make more sense? Because you can't, if there is no agreement, it's only the client that's going to be able to claim interest.
Right.
I think that we've answered the question at 89 to 90, and that question could be taken out. And I think that the bracketed language at 166 to 167 could come out, since we're not going to address that question. And that's all I have, and as far as I'm concerned, subject to the writing of a disclaimer, it's good to go.
Great. I would love for Ken to be able to confirm that he has no other concerns. But
I think it should wait till next meeting. And that's subject, of course, to everyone else's input, right? There's still a bunch of people who haven't had a chance to comment.
Great.
So do other folks have thoughts? Yeah.
Sure. So when I was reading the original, the 1993 advisory opinion, what actually stood out to me as missing here was the answer to the question about what do you do when the portion of the fee is disputed. And so, not doing a lot of fee arbitrations, I don't know how big of a question that is for the arbitrators themselves. So I would just say, before we drop that, maybe Ken can share his insight with you, Brandon, to the extent he hasn't already, about the significance of that issue and whether that's something that fee arbitrators are getting a lot of questions on. As I said, that to me was what stood out as missing from this opinion, and to the extent we're going to add something substantive to the 1993 advisory. Again, my gut reaction was it was the answer to that question. So I just flagged that as maybe something we can get a little bit more due diligence on before we permanently decide to drop it.
Yeah, I think that's a really good idea. One thing, when I was on the MFA committee, my understanding was that these arbitration advisories are a starting point to help arbitrators, but that they were always able to call state bar staff for tricky issues. I don't know if that's still the case, and it may shape how much detail we go into on some of these issues. So I'd want to talk with Ken, and I don't know, Andrew, if you have any insight as to whether people, typically you call your state bar local program and they have a presiding arbitrator, and Ken was doing it for the state bar. I don't know if that is still available, that you can call in and get guidance as you write your award.
Yeah, we can talk about that.
Okay, we'll look into that a little bit too.
And for what it's worth, because I think I've briefed this issue before, I think there's a Rudder Guide section on prejudgment interest in either the civil procedure or the civil trials and evidence Rudder Guide that probably has the answer or cites the relevant cases for this disputed question. So if we decide to include it, I think that we can ascertain the contours of the answer, and that might be a good starting point just from what I remember.
Okay.
Right. Anything else on the interest advisory? Thank you very much, Brandon, for all your work on this, and thanks to Ken in absentia. Now we're on to files retention, and we're actually running ahead of schedule when I get out of here. What a thought. So Amber, do you want to talk about your revised outline?
So this is the outline that's been, I think, significantly revised from the last version. And what I'm hoping to accomplish is that I'm going to get enough feedback from the committee to be able to have a draft by our next meeting. And the key issues that I think I would like to hear from the committee on, one is whether we should address the work product, uncommunicated work product issue. Two, the general structure of the opinion, whether it works. Oh, sorry. And three, whether the proposed hypotheticals are sufficient to cover the issues outlined in the memo, although I think that would depend upon what we end up deciding to keep or not. And well, let's start with that, and then I think we can get into the more specific questions that I have identified in the memo. Oh, one more thing, what to do about the prosecutor's duty with respect to file retention, which we don't really have we don't really have too many things on that issue. We don't have statutes, we don't really have case law, but I believe the California Supreme Court's directive was for us to look into that issue. So we have to at least address it, even if only to say, we've looked, we're not really sure what kind of definitive position we can take on it. Anyone?
I've got an opinion on your first one. I think we should address work product. I think that's an issue that comes up almost any time someone does a file request. And I think most lawyers don't understand what their duties are with regards to what they have to give up. So I would probably, if we're doing an opinion on this, I would include that.
Now, then the follow-up question is, does the committee's 2001 opinion do an adequate job covering that issue? I think it does, except with respect to the uncommunicated work product, which it expressly declined to answer. So should we just kind of recap what was addressed in the 2001 opinion, maybe truncate it a little bit, make it shorter, and then add a section addressing the uncommunicated work product?
I think this is a genuinely in part because there's there's like 6 or 7 episodes out there that bear on the question of what is the file,
right?
And what is the basis of the client's right to the file? You know, there are the opinions that say the client has the right to anything they paid for, right? What?
Well, so I don't like that because of the contingency fee cases and stuff. So
Right.
It's like,
well, there's also the ones
that
that
you bill the client for. I think there's one opinion that says that.
Okay, they bill it. Billing the client for is one piece. Another is some of this or all of it is client property. There are opinions that say it all belongs to the client, right? And then there are opinions that say, well, the real test is it necessary to continued representation?
Right.
Right, which seems to me to be the most compelling argument, right? It actually matters. But that means, of course, that in a malpractice case where the case is over, people will always take the position that they don't have to communicate the uncommunicated work product until there's discovery because it's not necessary for the representation. And so you're taking on a lot is all I'm saying. I'm not sure we shouldn't, but it is a lot, and I'm not sure how much of it is strictly necessary to the mission that that has been handed to us.
But to your point, if we're going to talk about an attorney's duty to retain or maintain client file, is it as useful to the lawyers reading the opinion to not be given any guidance as to what they're supposed to maintain and retain?
Right. And it might be another way of putting that is that maybe we can't intelligently answer the question of what you should be preserving without some view of what the basis to the client's right is. If it's a property right, then you could argue that you shouldn't be able to destroy it without informed consent, right? Whereas if it's a competence-based right, then the argument might be you can let it go whenever you decide that competence no longer requires that it be maintained.
And then I think there's a question about like fee agreements, attorney-client fee agreements, where there's specificity about the client, like for example, the document retention policy of a particular firm saying this is what we're going to do, and whether, to what extent, those are, I think, important and an attorney should have them, but like, what is it reasonable to have a really short period of time for document retention, for example, like by 6 months or, which arguably I would think would be an unreasonable period of time, but like I think that's an important part of that consideration too. Like, does the client understand the significance of like the need to have the file? Like, if a malpractice issue arises, and maybe we can't say like I don't think we should say like 5 years or I think that's problematic in terms of like saying a specific timeline, but like there could be some minimums we could talk about basically like based on like statute of limitations for malpractice or other things that we could, obviously the 5 years is based on the IOLTA, those records, and they would obviously have to keep that. But I think, I don't know, some of those things I think you're right that they're related, like the concept of like, how long do you keep the file? And then the question is like, what is the file, right? Like, because there's the question of turning over the file to the client, like at the termination of the representation that's been requested. And then there's the concept of like, is that the same file that you're then keeping as part of, whether you think it's a risk management protocol or your obligations to your client, for example, right? Like you turn over a file, let's say that representation ends and you turn over the client file, and then, but you don't turn over everything like you said, right? And then there's a malpractice claim that happens, and like you have a bunch of other stuff that that's arguably relevant to that, and like, did you have an obligation to keep any of that beyond that period if you've returned the file to the client, right? Like, which you deem as the file, right? Like,
and if you consider it in the context of what is reasonably foreseeable to protect the client's interests going forward, that then becomes even more difficult to define. But we should consider, if we're going to address whether what constitutes the content of the client file.
But I would think at a minimum it would be like to protect their interest. If you're saying about that articulation, I agree with. It's like, wouldn't the minimum be like the statute of limitations on malpractice is at minimum, right? Like, and then you obviously have discovery issues, which I know are a problem, but like discovery of when you learn about the malpractice.
Right.
Issue. Yeah, that's what I
that
mean by
could be
discovery.
25 years later for a trust and estate lawyer.
Yes.
Which you probably need to keep a lot more anyway. But,
yes. Yeah.
One other thing about the time limit, I can't remember where I saw this, and it could have been in one of our things with this, is if you give a time limit, the lawyer probably needs to follow through with actually destroying at the end of that time limit. I think I've heard some story somewhere about, a client basically assumed this file has been destroyed after 5 years, wherever the lawyer said, and the lawyer didn't destroy, and it was subpoenaed, and basically the client's own document retention policy got him in trouble. Right? Because
so the client didn't object because they assumed that it had been destroyed?
They assumed the client, you get a letter that says, I will destroy this file, I won't keep it beyond 4 years or 5 years or whatever it might be. If you don't do that, isn't that part of the client's own document retention policy? Right? A document retention policy is just how long am I keeping stuff before I destroy it. So the client assumes that all of their records from prior lawsuit are gone, but you don't do that because I'm going to destroy this in 5 years, and then you keep it for 20. It's subpoenaed, the client gets in trouble because of something in there.
It's really complicated.
I don't know where I saw that, but actually, this is not something that just came up, I saw it somewhere.
Right.
Where this was actually a fact pattern, some way that happened, or was suggested, or I can't remember.
Is that an ethics issue or malpractice?
It's probably a malpractice issue. Probably has nothing to do with, unless, it could, arguably, if you tell a client you're going to do something. And don't do
It depends. I don't know.
I say
Hi, Doc.
It seems like if you still have the file in the first place, you should tell your client, like, I just got subpoenaed and, that would, seems like a whole host of other, like, before just turning it over.
I think we're gonna want guidance from you, Amber, on how to think about this. My instinct tells me that it would be great if we could say something like, you can't destroy the client's property, right, without their permission, right? And whether they can give that permission in advance is an open question, but certainly they could give it. And then say, with respect to other stuff, this is civil cases I'm talking about now. You have an obligation to preserve everything that a competent lawyer would want to preserve for as long as is necessary to ensure that the client's rights are reasonable judgment, right? But you're entitled to make a reasonable judgment as to how long to preserve it in light of the likelihood that it would make a difference to the client's representation in some way or to the client's success in this matter. And maybe the rule would be, in many cases, that would be the malpractice statute of limitations, but it wouldn't be, that wouldn't be the actual limit. Would be looking at the client's situation. What could they reasonably need?
Okay, by that, the way you phrase the issues, that I think that you're then, so then we're not going to address specifically the work product issue.
If we are, we're going to address it in the context of some things are property, some things are things that the lawyer keeps because of their continuing obligation to make sure that the client's interests aren't damaged, right? And we don't necessarily then have to say whether that stuff would be producible in response to a request, right?
True.
I mean, is there stuff out there on defining exactly what the and expanding the concept of property to?
There is some, including the ABA's, I can't remember if it's the cyber attack or the disaster opinion, but there's some messing around there with the question of whether the file is client property, and there's also some stuff like that in some of the ethics opinions.
I think
Hi, this is David. For what it's worth, the Office of Chief Trial Counsel ascribes to the property theory of the client file. And in terms of undiscovered work product, their position is also that everything, including undiscovered work product, is the property of the client. So that's kind of where the discipline folks are coming from. I reviewed a fee agreement yesterday for a marital dissolution lawyer whose client retention policy said, we can, at the conclusion of the representation, you have 90 days to get your file, and we will destroy the file at the end of 90 days if you haven't asked for it. And my gut reaction was, well, 90 days is much too short, despite the fact you're spelling this out in the fee agreement.
I agree. That's a good hypo, actually, I think, to say, I mean, if we had something like that where it seemed like it was obvious, if we all agree that that was like obviously not sufficient to protect the client's interests in the event of like a malpractice claim that's discovered or other things, that we could use that.
That does amount to, that seems to me that also falls under the doctrine that you can't by contract waive the lawyer's duty of competence.
Yes, and that was sort of my analysis as well, that, well, you really, 90 days is much too short for any number of reasons. And of course, in a marital dissolution case, issues can arise years after the initial representation.
Yeah, I like that hypo. Okay. And, you know, Steve, your idea of how to address the content of the file issue, folding it into the overall duty to maintain and retain.
I'm just remembering, isn't that sort of the framework that the
Right,
earlier
I was
opinion
gonna say, I
uses?
mean, it certainly simplifies the opinion, and I think perhaps it does address the directive better.
I think David's comment complicates things, right? Because if a branch of the bar is taking the position that everything is client property,
Right.
right? Then the argument would be you can never destroy it without client consent. It seems to me if it's really client property, then you'd think informed consent would be essential, right, to the right to destroy it, or at least, informed consent or I've seen provisions where people say, we'll contact you at your last known address. You have to keep us at least posted as to where you are. So it's either informed consent or constructive abandonment, right, in some way as the underlying principle. And so there's something to be worked out there, and I don't know what the answer is, right? Because I'm not sure the state bar is right, although as we know, we may not want to take that on. They may not be right that it's all client property, particularly in contingent fee matters and so forth.
Is that predicated on the 2001 opinion where they discuss bailment law?
Right.
Is that a property analysis?
I would say that's a property analysis.
Right, like you're my bailee, I'm giving you my jacket, I'll come back after dinner.
I mean, I
Can't
do agree
destroy
with
it.
Steve, it raises some like complicated questions of I think people assume after some period of time, like 5 or 7 different years of, that recommended is reasonable, that they would be able to destroy a client file, and if you don't have that in your fee agreement, related to that, then are you required to keep the file to infinity? I mean, I don't think people would think that's reasonable.
No, right.
Unless it's a
I'm
particular type.
not trying to suggest that, and you could maybe contract for an alternate result. I'm just trying to highlight that this committee's taken the position previously. I'll have to reread the opinion more closely again. It's been a while. On the bailment provision, my gut reaction is that's a property.
Well,
But that's only for the papers and property received from a former client.
and that concept actually
originals.
Yeah.
Was first raised in the BASF opinion that the committee then referred to, and that was in the context of distinguishing, in the context of explaining why the committee was not going to adopt a specific time period for file retention purposes like LACPA recommended. And the reason that it was not going to is because you can't put a time limit on, when you get to destroy the client's property of which you're holding as a bailee.
So here's a possibility that might take the OCTC out of play. If we took the view, I'm reading now, looking at 2001-57. It says, as to original papers and other property, right, the attorney's duties are governed by the law relating to bailments of the probate code. And it goes on and says, with respect to other client papers and property, right, it says absent a previous agreement. So one question would be, what does a previous agreement permit or require, right? The attorney has an obligation to make reasonable efforts to obtain the client's consent, right? And even if they have made those reasonable efforts, they still have to make an independent judgment, right, about whether the preservation is required by law or it would cause prejudice because they're reasonably necessary. That framework actually still seems to me to work pretty well for what we're talking about, doesn't it? I mean, and it doesn't lead, because even if we assume that the papers and other property include uncommunicated work product, we're getting the answer we want, which is you have to try to get client consent. And if you can't, you still have to decide whether this is reasonable to preserve the stuff. That sounds like it might give enough protection, even under the OCTC's view of the matter. And then we still have the question that was raised of what about an advanced consent? And the hypothetical that David put forward is a great one for testing that, because
Right.
there are clearly some kinds of advanced consents that wouldn't be enforced.
Right. The lawyer's independent judgment, if we're using that framework, would hopefully not believe 90 days is reasonable for some of the reasons Dean identified.
Right.
And no malpractice claim. And then the other issue this is all circling around is it's so fact dependent. What type of case were you handling?
Yeah.
Right.
What's in the file? Like trust and estates documents are, and criminal files are vastly different.
And also there, I mean, obviously in those matters, there will be documents that you can't ever destroy. You have to get the originals, so.
My sense too is when a client requests a file, maybe they're transferring to their attorney or something before the termination, or that it's, like you said, there's a lot of sometimes documents that are withheld that because the attorneys analyzed and said that's not reasonably necessary for representation, or this is like a draft of the letter that I never sent and then I revised it, and all those things. But I also have probably a sense that like most of those firms probably keep those other things that they didn't provide to the client for risk management purposes, for malpractice claims, longer than that, and that just kind of creates this interesting question about like, well, what's the client? I mean, you know, not that necessarily can get into that from this opinion, but like
Memo to file about client.
right, or like do they give every text message they've ever, you know what I mean? And sometimes the client doesn't need it for a purpose that's adverse to the attorney, so it's not like they even maybe want all that stuff. I mean, sometimes there's like just certain things that they want from the file, but like you would still have an obligation to preserve like the entirety of, you know, all the communications related to the representation and
And
everything.
you know, the question is actually easier to answer, you know, if the client actually makes a request for the client file, because I think it forces the lawyer to think about, okay, the client's asking what's going to be necessary for the client's continued representation of the client in a matter, whatever. But if the client doesn't make the request, and you are, say, thinking about going paperless in your office, and you're thinking about what is it and isn't necessary to be kept, including, you know, uncommunicated work products or drafts of documents, like it makes the question a little bit harder to answer, I think.
Although much could depend then on, I mean, here, this comes back to in some ways to the agreement point. I've seen retention agreements where lawyers say things like, our uncommunicated work product, you agree that our uncommunicated work product will be our property.
Yep.
Mm-hmm.
Yep.
And that at the end of the day, you won't get it.
That's I've seen that too, and that's an interesting issue about whether, I mean, I don't want to expand this beyond what it is, but that's an interesting concept for whether that's.
We may want to stay away as much as we can from those disputes about what information the client has the right to, and focus it more on competence-based stuff, right? And on consent and competence, like the two concepts that drive this, at least in the civil context. Amber, what about the criminal context? The question that really grabs me is we have a bunch of opinions that say you have to preserve criminal files for the life of the client, right? Which includes misdemeanor cases, right? And presumably, my first question would be, presumably that's all subject to client consent, right? Again, right? Or is it?
What do you mean?
Well, I want to think about that. I'm not sure, but two things to think about. One is, we now have a statute that says that the lawyer's obligation to preserve in criminal cases, in serious criminal cases, right, the sentences of 15 years or more, is limited to the length of the term of the sentence. What implication does that statute have for our ethics opinion that lawyers have to preserve stuff for the life of the client?
Right, and that's one of the questions that I actually identified in the revised memo. Should we say, notwithstanding the revised or amended penal code, stick with our original advice that all files in criminal matters should be retained for the duration of the client's lifetime, including, absent the client's consent. But in any criminal matter,
Well,
And that was the opinion
yeah,
in 2001.
and the reason they justify it then is, I think the Three Strikes Initiative was recently
Right.
passed, and I think those did apply to misdemeanors. Again, I take the client protective view, but criminal files are, in my view, are of a different nature. We've had the standard out there since 2001. I'm hesitant to recommend that we reduce that standard or alter it absent some really strong, compelling reason. Yes, there's a statute, but there's nothing, the statute doesn't prohibit us from putting a grade or responsibility on the profession.
And that's where I think that's where I come out
Those are
as
my
well.
views.
But
I know it's difficult and it's burdensome, but heck, I mean,
Well, there is,
you don't have to be a lawyer.
There still is client consent.
Absolutely, you should. And there's another element I shared with Amber that the opinion could touch upon, is once you get the consent, how do you destroy a file? There is an opinion that talks about burning or shredding. I acknowledge my email to Amber. I don't know how many people are doing bonfires with the client file, but in the digital age and with however records are kept these days, I think it's worthy that this opinion address in a small subheading.
like a best practice.
Yeah, or
I agree with
your
you,
duty of
yeah.
confidentiality.
Yes, confidentiality.
Yeah, and just be quite careful and know what you're doing and do it appropriately. You owe that to the client.
You have the obligation to avoid inadvertent disclosure of
Totally.
confidential
Yeah,
information.
all that stuff. So that's my view on criminal. I think trust in estates, although I'm not as familiar with that, I think poses.
Anyone has a different opinion about sticking with the recommendation that we recommend that files in criminal matters be retained for the duration of the client's life.
Right, although I think then it's important, I think it's very important at that point to spell out the consent provisions.
And you're right.
Although all this is, the worry about having, since you can digitize stuff, I worry less about this. People aren't going to have a warehouse.
Right.
To fulfill this obligation.
We don't have to think in law school, they should say, all right, for those of you who are interested in criminal law or states and trusts, you should be aware, you're gonna have to keep your client file. If you don't work for a big firm that does that, you're gonna have to keep your client files forever.
Now, that being said, I've heard anecdotally of some files that are extremely large. You gotta buy, an extra storage device, and I don't, again, never experienced this personally, but from what I've heard in this one anecdotal example, that can be somewhat expensive.
That ought to be a consent situation.
I agree. I'm not saying it works. I'm just trying to be fair to people. It's not always so easy just because you can digitize. One other thing, someone reached out to me about the concept of, and I don't know if we have anyone who has experience with this, but because it's not addressed in the prior opinions, I think it would be nice if we could also include this as juvenile dependency cases. I don't know what all the issues that arise there, but I had a juvenile, and I could maybe get, if the committee thinks it's worthy including this as a subheading, as a subject area. There's a practitioner who reached out to me, and he's very concerned about the ability to get adequate files from in juvenile dependency settings, that lawyers aren't adequately retaining those files in a similar way that criminal files are being maintained, and that ethics opinions do talk about trust in estates and criminal files, but none address juvenile dependency matters, and he feels his practice area, not him personally, but the practice area is ignored.
So what are the issues there?
Good question. I'll have to see, but someone not being maybe you have experience of not being of age of majority yet. Lawyer doesn't worry as much about those files because of that fact. Something occurs related to the fact of the juvenile dependency issue after the client becomes an adult and they're unable to track down their file. I don't know exactly, it's just general.
It just seems to me that that could be a question in and of itself. I think juvenile dependency is really complicated.
Okay.
And the implications can be, in all cases, can be significant, but in these cases can be very, very significant, and I just think it's worthwhile to look at it. I think it's an important question, but I don't know if it should be folded into a general
Okay.
discussion.
I mean, that's the other thing, is they may request an actual full-blown opinion, and if that happens, I wonder strategically if we'd want to fold it in, or as Toby suggests, take it.
I guess at the minimum, we should find out.
Yeah, of course.
It may be that we're giving enough guidance to those lawyers by publishing an opinion, and we could suggest how it might apply to it by analogy. Right. One of the things that strikes me about a juvenile dependency proceeding, I don't really understand the details of it. If the juvenile is involved, right, maybe they don't have the capacity to give the same kind of consent, right, to file retention and so forth and so on. The second thing that occurs to me is it could have continuing life consequences in some way that are analogous to a criminal case, right, under the three strikes analogy. And it may be that we may be able to suggest analytic hooks in a more limited opinion that nonetheless provide guidance to people who are in the field.
And share his observations.
I mean, would there be an issue there with them, for example, like lots of those records can be expunged too if they're of a criminal nature, and maybe they want them destroyed and don't want them to be used against them later as an adult, or like, yeah, I mean, there's probably a lot of issues.
Okay.
What about prosecutors? That's the.
Oh, yeah, prosecutors.
So one thing I wanted, I don't want to cut off the conversation. One thing I wanted to mention, you had this list of authorities, and I think I sent it to you in the email. No one knows what the Supreme Court will say about our proposed revisions, but in a draft opinion, I think it's worthwhile. I don't know how helpful it'll be, but it's worthwhile to use that as a citation, our proposed revised comments. Help both bring attention to the most recent penal code revision to sentences of crimes of 15 years or serious crimes that are 15 years or more. And we do a pretty good job trying to flesh out the issue of file preservation orders and the prosecutor's obligation to comply with those. That could, although not fulsome, that's a slice of an issue that a prosecutor should be aware of, and the case law is pretty supportive of that. We could maybe work on
Which is, again, remind me, I was trying, not thinking harder.
So our amendment to comment 7 of Rule 3.8, there's just a limited number of penal code statutes which talk about file exhibits and certain forms of biological evidence.
Consent, which have an informed consent provision.
Yeah, and those are narrow and specific and depend on the facts and circumstances. But then we added a second sentence, which I think is more fulsome, broader applicability, and that is, if a court
The doc preservation order.
Absolutely.
Yes, absolutely.
Yeah.
Right,
And
and
that
that
assumes the prosecutor has the file.
Right.
There's a lot of issues there, but I think bringing that to the attention of the practice.
But that would be, that's, and as I recall that opinion, it's limited to situations where, where it's discoverable.
Yes.
Within the meaning of.
Under 1054, that's right.
So those are, I think those are two helpful points. I was gonna say that going beyond that, Andrew's absolutely right, we can say that. Going beyond that, I think we have to say we don't have anything to go on. It's a bunch of stuff, and it's the government code and a bunch of stuff like that. And it's not, my feeling is, and a bunch of guidelines, it's all very, and none of it is hinged to any ethics rule that I can see.
there's no real competence issue. I'm just trying to think.
Right.
I mean, their duties are to the state.
They don't have a client in the conventional sense, right? So these rules really don't apply to them, it's hard. And the statutes don't really apply to them except for this stuff.
And maybe that pointing that out in and of itself is a helpful and useful thing to do.
I think so,
And-
from a law reform perspective.
Right.
Absolutely.
And when that section gets flushed out, I'm happy, or if Steve wants to, based on his prior contact, I mean, we can run it by George Cardona. He's a former federal prosecutor, helped on the Rules Revision Commission, he's now city attorney in Santa Monica. He's very articulate, great writer. I don't know what he would say or if he would entertain our request for help, but it's worth a shot. And if anyone knows anything, it would be him, or maybe he could guide us to someone who could help. I think I just recommend that step for ourselves, doing our best due diligence and trying to tackle the issue.
Or our new San Francisco PA.
Yeah.
Who may have a
Different view.
different view.
Does that give you enough to work with, Amber?
I think so.
Right. It feels like you're very close to a kind of working outline of what we want to accomplish.
Mm-hmm.
That's great.
No, this was really helpful.
David and Brandon, do you have anything to add?
No comments from me.
None from me either.
Thank you, Amber, for taking this on.
Yes, I'm actually looking forward to actually start the drafting process. I think it'd be good.
You should, if you feel like you want to move to the drafting process, I think you should.
Oh, I'm sorry. Maybe I misunderstood where we were. I thought that's what we were getting to. Were you thinking about revising it as an issue memo one more time?
I didn't have a view.
Oh, okay.
Your comment crystallized a view, which is that I think you're ready to start drafting if you.
I think we should. I should.
I'll put the
You have a
assignments,
committee?
prepare an opinion
You have a
outline.
committee?
Well, you're on it, Steve.
I know, but I mean, okay, I'm good.
And there-
Who else?
And there
Anyone
was
else?
a third person, but I can't remember now who the other subcommittee member was.
Ken Bacon.
Okay.
Okay,
Okay.
that's, if you want more, right?
Is there anybody, yeah. Should we-
Anyone else interested?
I think it would be helpful. Well, you can always chime in next meeting. Volunteer next meeting. You have to do it this one.
All right. The next up, we have three things left on our list. We have expert witness, succession planning, and costs. Expert witnesses is the one that comes up first, and this looks like your.
I think you might have taken some of my stuff, actually.
Did I take your stuff? No.
Yeah, I think you got a couple of my things here.
What else have I got?
So
What else do you have?
JJF, I'm gonna say those are mine.
Yeah, I guess so.
It's
And
like,
that's
this
yours
opinion
too.
from Steve is awful.
Oh, that's good. I feel so much better now. That's good. Now,
Tristan's like, can I have some?
well, I don't know. That's, I don't know whether I owed you a duty of care or not. But clearly, I violated a duty of care, so I owed you one. All right. So this expert witness thing, I thought would be. I had when I began, I thought it would be quite straightforward, and in some ways, I think it is. If you take the analysis that we argued in our draft opinion on ancillary businesses, if you take that analysis seriously and you apply it to an expert witness, there's a pretty good argument that the rules of professional conduct shouldn't apply to an expert witness. We don't opine on issues of practice of law, but it's hard to view being an expert witness as being a practicing lawyer. doesn't take a license, and there are a lot of other differences that are relevant. Even if you thought that a lay client might somehow reasonably entertain a view to the contrary, right? It would be very hard to argue that they could do so if the lawyer, if they were represented by counsel, right? And which most people who hire expert witnesses are. And in particular, if the lawyer expert witness says in the retention agreement, I'm not practicing law, and our communications are not subject to the attorney-client privilege. So that, for a testifying witness, it seems reasonable to say that they're either not covered by the professional rules, or if they are, they can avoid that coverage by being clear in their retention agreements to exactly what's going on. And so that's one line of analysis. Another line of analysis would say, what do the rules actually say? And the rules typically apply to lawyer-client relationships. And if you assume that this isn't a lawyer-client relationship, then the rules ought not to apply. So you can sort of come at it in two ways. One is the common law analysis of when the rules ought to apply to non-practice of law activities. The other would be a rule-based analysis when the rules purport to apply to particular kinds of conduct. And the argument in the memorandum is that those arguments both basically work. Now, one thing that I should note is that I've only done the analysis of the rules with respect to conflict of interest, because that's where most of the case law is. So I haven't looked at questions like, what about the trust account rules, for example, if you're collecting fees? Might those are, on the sort of, it's clearly not the practice of law, and it's been explained to be such analysis, it wouldn't matter, right? Those rules still shouldn't apply, but on the sort of, we look at the text of the rules analysis, that analysis is missing here. And there might be other rules we want to look at along those lines to see if they somehow reach a different result than the conflict cases, right? Another issue here is that there is this body of law, which Andrew referred to earlier, that says that if you're a fiduciary, you're subject to the rules of professional conduct. Well, do you think of an expert witness as a fiduciary? Certainly that would be an unconventional characterization in ordinary terms, right? But they are an agent, and agents owe fiduciary duties. And so you have this odd question then, right, of whether you might want to blow that fiduciary duty up into a notion that the lawyer is acting as a fiduciary. Then you add the further piece and you say, well, now they're subject to the rules of professional conduct. And then if you take OCTC's view, and the lawyer can't disclaim it, right? Now, I'm not trying to create a parade of horribles here, but I am wanting to flag that issue, right, as one that shadows this kind of analysis. And I think that's probably enough to get the discussion started. And if people want to pass on their thoughts.
Well, I have a comment, kind of a question on that note of what you were just talking about as being a fiduciary. What if you're an expert who's not licensed in California, an attorney but not licensed in California, but comes into California and acts as an expert or acts as a fiduciary?
As a testifying witness.
Right. Then would they be subject to the California rules?
Well, the argument here, which I haven't researched in that context, but the argument here would be no.
Right.
Because you're coming in and you are not practicing law.
Right.
And what's more, nobody could reasonably understand you to be practicing law.
Right, and so I think that kind of plays into what you were just talking about.
Absolutely.
If that is the situation for somebody outside of California who is a lawyer, but is just not licensed in California, then why should there be a different standard for someone else?
I think that is a reinforcing point. I kept thinking of the example What about a lawyer, think about this, an expert on foreign law, which is the only kind of law basically you can have expert testimony on. An expert on foreign law comes into a California court and testifies about foreign law. Are they practicing law?
Right,
They aren't,
right,
right? They can't be.
right, so how
Right?
can
And
you
they
have
can't,
different
and you
standards?
couldn't possibly bar the leading expert from a foreign country
Right.
from coming in and testifying to foreign law on that ground, right?
So I think
And that
that
suggests
supports-
that the lawyer really ought to be able to put it in their retention agreement that I'm not practicing law, and that ought to be the end of it.
Right.
Right? Yeah, I agree. Yeah.
So what I'm wondering is if and how we grapple with the comment 1 to rule 8.4. That being that you can violate that rule relating to misconduct even if you're not practicing law or acting in a professional capacity. In other words, an expert witness who's a lawyer is still subject to the rules of professional conduct.
They're still subject to 6106 violations and 8.4 BC type violations.
Right.
I don't know that they're subject to all the rules of professional conduct that apply only to the practice of law. In other words, that is to say, if you're not practicing, you're certainly can be subject to discipline for conduct that's not the practice of law. But normally that would not be, that would normally not, that would be like moral turpitude kinds of things. Deception
But
kinds
I
of
mean,
things.
sorry,
Go ahead.
it's just like the concept that you're bringing up, it's like thinking about, like, we've been saying that you're not subject to the rules of professional conduct, but isn't it really that, like, you don't have an attorney-client relationship with this client, and then some of those obligations related to that you would have to clients don't apply, but these are not related to necessarily obligations that you would have to clients, they're general conduct, like other duties you have as an
Right, I
attorney
think
don't
that-
just relate to how you deal with your client.
So I just want to make sure that's what we're trying to say here is, it's not that an expert isn't necessarily subject to certain rules. It's that they might not have other duties or obligations under the ethics rules just because they're serving as an expert. Is that what we're trying to get at?
There's no attorney-client
There's no
relationship.
attorney-client relationship.
relationship or whatever. Other
And they're not representing a party in court and so forth and so on. There's a variety of different ways.
So because they're not a client, you don't have to put the funds in IOLTA. I mean, but it's not necessarily that they're not subject. I mean, this was always that language that was like hard to kind of put in a way that I think people felt comfortable with, even with the other opinion, right? Like avoiding the rules or how to put that in a way that didn't make it seem like you're
Subject to the, I would say, subject to the professional rules applicable to representing clients in the practice of law or something.
Right, so we need to, I think, add that nuance, because
Yeah.
there's a sentence in here that says, applying these principles, goes on, the rules of professional conduct should not apply. And so I think we just need to be real clear that it's, the rules that we're really trying to get at here, not that that 8.4 doesn't apply or.
No, and the opinion, actually, the memo says right at the start that 8.4 does apply. One of the first sentences in there. Always subject.
Right, and 8.4, and if you look at comment 1, that applies even when you're not practicing law because of the context of the.
A lawyer is always subject to discipline, whether or not engaged in the practice of law for conduct violates provisions like Business and Professions Code 6.6 or 8.4.
Right, so I'm just saying we want to make sure once this is more fleshed out in opinion, that how we describe the rules applying or not applying, we just do that consistently. Because when I saw that in 8.4 and I was then thinking, okay, there's going to be a discussion of 8.4, and then I saw the statement that the rules of professional conduct should not apply, and I recognized that it's not what you were going for,
right?
But I think it's worth kind of
You're absolutely right.
keeping in mind as we go along and turning this into a.
And that should be clearer, and it should deal with the concern that Dina identified too, of not making it clear that we're trying to get, that the lawyer's trying to duck anything here.
Yeah. Are you self-comments?
I
think one interesting thing I think about this opinion is like the sort of brief discussion about consulting experts versus like testifying experts, and I definitely think that needs to be fleshed out, and it's a really interesting thing to have identified because, and maybe we can think about.
The ABA identified it. I
Okay,
just
but
followed
thinking about duties that you would have, like obviously starting out as a consulting expert, you have those obligations to either the law firm that hired you or the client or both. And then the idea that like if you would somehow turn into a testifying expert, which I think that's fraught with problems, and I think we need to identify that too, because I think then you have to say, I mean, most.
You might have to say, I know too much, don't turn me into that.
If I'm gonna be your consulting expert, I'm not gonna be your testifying expert, right? Because I'm subject to all kinds of, privileged communications, which then are just, you're opening the floodgates. And so I don't think doing both of those things is very advisable. I'm not gonna say that we should, say you shouldn't do that, but I think we need to identify the risks that need to be disclosed to the client about transitioning into that role.
Absolutely, and the ABA opinion makes a good start on that. And I would think that we would want to do that, again, with having in mind, among other things, California's distinctive confidentiality rules and so forth. So, absolutely, I agree with that completely.
What context are lawyers experts in? I mean, I've only got two main ones that are coming to mind, standard of care and ethics. What else is a lawyer really?
It's interesting, there's a lot of.
Testifying expert.
No, and it's interesting to read the California cases, right? There's an expert testifying on diminution of the value of property, right? There's an expert, several cases involving experts testifying to
lawyers?
Practices in the insurance industry, claims handling practices and so forth and so on.
Or tax issues if they're tax counsel, like they can testify on tax matters.
But ordinarily, you're not usually testifying to a matter of law. You're giving testimony that, as the way the California code reads, you're giving testimony that is helpful to the trier of fact, right? So you're not, and these cases, typically it is factual, essentially. It's based on the lawyer's experience and seeing a bunch of different transactions. Standard of care is typically viewed as a factual issue. What's the standard of care?
Right.
Right. So it's mostly questions about a range of different things.
Which, to Kendra's example, take it a little further, I guess. And what's the difference between me hiring a lawyer for standard of care and somebody else hiring a doctor?
That's exactly the argument. That's exactly the argument in this opinion, except for the risk that somebody might understand that the lawyer is providing legal services because they're unsophisticated, right? I think your question, you raised a really good question, which is something like this. Should we be saying that you even have to make a disclaimer, right? That you explain in your retention agreement that you're not, is it so obvious that no one could reasonably think that you were doing anything different from the doctor who's testifying?
Isn't it on the lawyer hiring the expert to make that disclosure to their own client?
I think that's a totally reasonable argument, which I ducked here.
I feel like you can say in one sentence, I'm not providing legal services or acting as your attorney, right? Like, I think that's,
Well, it just seems like you can't, we seem to be, maybe this rule, confidentiality, we talked about this last time, but confidentiality clearly doesn't apply. Right? The second you disclose someone, there's no more confidentiality. It doesn't matter if they're a lawyer or not.
No, that's not how it works, actually. It's
not
until you put them out there and they've actually given testimony.
You're right. They have to testify, which is why people are consulting experts until the moment they're testifying, right? I've pulled testifying expert before because I didn't like what they said, and now they're consulting for the rest of time.
but some people bring you in as in that role to give advice that they don't ever anticipate that you're going to be testifying, but you have a particular, expertise in a matter that they want to get feedback on. It's in addition to the advice they're giving to a client, which that's why I think that distinction is important because I don't think you should, that strategy that you're talking about is you hire the person, then you don't like what they're going to say, so they're the consulting expert. But sometimes you take on retentions where you're really serving in that role as a consulting person, and you would say to them, I won't be testifying at trial because I know, you're actively involved in strategies that are.
Isn't that more isn't that more confidentiality under the fact that they're an agent at that point to the client? So you don't have to be a lawyer necessarily if they're a consultant. the reason why those conversations are confidential at that point in time is because they're considered an agent of the client.
I'm not quite sure how far we want to go into this. There's
Yeah.
a lot you
No,
could
I
say.
know.
Because they're relying on legal advice, and many times the expectation is that you're going to provide legal advice that they're going to rely on.
Right, I think that it's somebody speaking from up in the cloud there? Did I hear somebody talking from, Orange County?
I don't think so.
Okay,
No, not from us.
Okay, sorry. I guess what I was gonna say is I think you're absolutely right, Kendra, right, that argument is available sometimes, right? Often, the ABA opinion sort of assumes that if you're, and this draft doesn't take a view very clearly, the ABA opinion assumes that if you're retained as a consulting expert, you're ordinarily gonna be an attorney.
Right.
You're being retained as a co-helper. They say you're more like co-counsel.
Yeah.
Now, it's in theory possible that it's so clear that you're only going to be talking about some factual matter that you know something about or where you have expertise, right? In which case you could make the argument that your only obligation is one of agency.
Yeah.
Right?
I
But I'm not sure we want to get that deep into it.
Well, I know. I just think that, I mean, I haven't read that ABA opinion in great detail that you're talking about, but I think there is a line that is drawn there. And I think that I don't necessarily agree with what that ABA opinion is saying, that kind of blanket cover that you're assuming
Right,
to be.
I agree that there are some people who could sneak out the other side,
So,
right? But I'm just not sure we want to
right, but I think
spell out
my
exactly how
point
that
is
might work.
that you've got to be careful when we're doing this because there are going to be some of those other things. So how do we avoid stepping into some of those issues?
Well, I think you're right to urge caution. I was trying to avoid stepping into it.
Yeah.
Because but it seems to me that one of the ways we can do this is to write a hypothetical, right? In which it's clear that the expert is being consulted with respect to their legal expertise, right? In which case we can simply say, well, that's different. And we don't have to spell out all the delineations between the consulting expert who is being consulted for legal advice and the testifying expert who can't testify to the law. We just have these two extremes, and we work the opinion that way without trying to work out all the gradations. That's a possible way to do it anyway.
What Kendra's saying,
Sorry to interrupt. I just want to remind everyone to turn on the mics when you're speaking, because the captioner did call me. They were having some trouble hearing sometimes.
Okay.
So just kind of remember to turn it on when you speak, and then for those who speak softly, just kind of speak up a little bit. That's it. Thank you.
So I think what Kendra's saying, I hope, is if I consult with a damages expert before they start testifying, and I don't like what my damages expert is going to say, my damages expert can't go tell somebody else that it's privileged because it's a third-party consultant within the case, and it's a privileged communication. So how is that different with my damages accountant, or forensic accountant or whatever it is, than a lawyer? Just because they're a lawyer,
Yeah, that's
their confidentiality now becomes attorney-client privilege as opposed to third-party privilege?
right, because it's not the privilege of the expert. It's
Mine.
it's your privilege with your client, and they're a third party.
I guess the distinction, and maybe it's not using the word, the consulting. I mean, I know exactly what you're saying in the context of hiring an expert, and in that case, you're going to hire this consulting person, and you're probably going to be really cautious about the information that you give to them because they may turn into being a testifying expert, in which case everything you've ever said will be disclosed to the other side, correct? So they're hired as an expert in that way, and there is clearly not an attorney-client relationship or an implied or otherwise in that context. But sometimes people hire people to serve, and maybe it's more the co-counsel thing, but I think there's sometimes this blur where people retain you to give legal advice on a particular, and you clearly would have an attorney-client relationship with them. Then they may want you to serve as an expert witness on a particular topic. Like maybe this is a matter that has a lot of different legal issues. There's a portion that deals with ethics. You're brought on board to give opinions about ethics to them to help shape whatever the goals are of the case, right? Later, they may say, hey, it would be great if you could testify on this particular issue, standard of care or otherwise, something related to a particular ethics piece. I mean, I think that situation, and maybe we don't address it in here, but I think there are times when people give legal advice, and maybe it's not expert testimony, but as sort of like a special, that they're specializing in that practice, or they're hired because they're quote unquote like an expert in that field, and then that could later turn into what they, maybe testifying on those issues. And in that case, I think that should never happen, because you're going to, then everything that you've learned in terms of like attorney-client privilege would be
blown.
I agree with that, but so, I mean, I do a lot of legal malpractice right now, right? And I don't know half of the subject matters that I'm working on. So I need to hire, and I've got a condo conversion or a trust and estate or whatever it might be, and I don't know that. I know how to do legal malpractice.
Right.
So I have to hire an expert in almost every single one of those cases, but I've never once considered that expert to be co-counsel, right? I've done it defending lawyers, I've done it
do you share attorney-client privilege information with them?
Yes, because they're an expert, because I'm hiring them as a consulting expert, but I am, as the attorney, it's my job to make sure that whatever it should, that's why you don't let an expert talk to the client.
And I guess that's the difference is I just think we should make clear those different scenarios that,
I think we should be clear, whether we opine on each scenario is one question, but we should make clear that there are these different scenarios. And as I hear you guys, what I hear is a lawyer could be testifying, could be consulting potentially with a view towards testifying, or maybe not, but just with respect to a factual issue, right? And then the alternative case is the case where the lawyer is actually providing legal advice, or is hired and provides legal advice, and then somebody says to them, switch hats. Those would be the sort of clean versions.
Yeah.
What?
Yeah, and I think that's problems.
What?
I don't know that you can provide legal advice
Mm-hmm.
and have a relationship, whether it be as co-counsel or whatever, and then switch hats.
Well, certainly you can't do it without the
Without
client's
client
informed
consent.
consent,
They could
for
consent to
sure.
it.
They could probably consent to it.
But I think the reason why I brought it up is because I think it supports what you're saying here. And if we look at it from that view of, could this person do what they're doing as a non-lawyer, and if they can, then, then the rules wouldn't apply.
I think.
And then they might be under the umbrella of attorney-client privilege, but it's not that expert's umbrella, because they're not representing the client. It's the attorney's umbrella, and that third-party expert or consultant is just.
I completely agree with that analysis.
So I think that would work for us here. It would serve the purpose of the conclusion we're trying to come to look at it that way.
Mm-hmm. Well, I hear that we want to be very clear about what we're saying about consulting experts, and that we want to distinguish between consultants who allow themselves to go into the legal role as opposed to those who are in a purely factual role.
What duties, if anything, does that consulting attorney in your scenario, like the HOA person, have to you or to your client, if any?
I think none. I mean, they have. Yeah, I mean, they have their, but, so, I mean, the premise I've got the problem with is an expert needs to be truthful, right? They have to testify under, and this is back to testifying, but you can't be an advocate and testify under oath, because you may, by nature, have a choice between harming the client, if you're gonna call it a client, or perjure yourself, right? I mean, you can't, it's a factual, an expert is a factual issue. If it isn't, and maybe I'm just getting hung up on the term consulting expert and thinking that is co-counsel. Because to me, if you are a consulting expert that has a duty to the client, you're now co-counsel. You might not be trial counsel, but you're co-counsel, which is a different thing to me than an expert. right? If I'm hiring, because I rely on experts, I suppose, when you're asking for legal advice all the time. What was the standard of care? Which is not, that's a factual question within a legal malpractice lawsuit, but it's absolutely a legal issue and somebody giving me legal advice on what the standard of care is.
Well, legal advice, the standard of care is not a legal question.
Well, right, theoretically no, but it's somebody giving me, this is the law, I'm applying the law to this facts and circumstances, and this is what should have happened or should have been done, and here's how it, I mean.
Right, well, so I'm just saying that if, I'm not sure who's gonna carry this opinion forward, I would be happy to have someone else carry it, by the way. But it does seem to me that it's absolutely right that we should be very clear what we should talk about consulting experts, and we should be very clear what kind of consulting experts we're talking about.
Right.
Right? And we should at least know what we think, whether we opine on it. We should at least know what we think on how the two different scenarios, right? The one where the lawyer is providing legal advice and the one where the lawyer is being consulted purely on a factual basis. We should be clear on how the duties in those two circumstances differ, right?
And I mean, I guess that would be largely dictated by the engagement between that particular attorney/expert and the attorney or client that engages them, right?
One thing that's clearly relevant here is the sort of shadow traffic, all those cases about contacting the other side's expert witness, right? Where, it's clear that if that a lawyer who consults somebody else who's been the other side's expert witness, right, and gets attorney-client privileged information is disqualified.
Well, yeah, that's what I was going to say, because we didn't even talk about that American Airlines case, which is a very interesting case.
Yeah.
The context, and that's like, you have this pre-existing attorney-client relationship, then you act as an expert against that client's interest.
Right.
Not okay. What if you're an expert and then you later have a situation in which you're, retained by someone who's been adverse to the person that you testified for? I mean, that obviously I don't know that there'd be a conflict application there, but
I think those arguments, I think it's right to say that if your obligations aren't specified by professional rules, they're going to be specified by common law. They're going to be which includes the contract of retention, but may also include certain expectations, right? The person who, for example, does a consultation and takes money for talking with a lawyer in a situation where those conversations are privileged, and who then if they then walked out and marketed themselves to the other side, that would look like like some kind of gross common law violation.
But I do think, it should be explored to some extent, the concept of like whether there's the requirement of some kind of disclaimer, and I know you said you avoided that situation. I just think that we can assume that most attorneys are sophisticated about these things, and they absolutely 100% should be, but the idea that an attorney comes into the picture, I think people automatically have this concept that this attorney-client privilege applies, right?
Right.
And your attorney, yes, should be explaining to the client what the role of that person is in the case, and in most circumstances, that person that's coming in as an expert probably will never talk to that client, but they may in a group setting, but I think that's probably worth thinking about at the very least, because I think, and even to what extent the attorney is going to say things to that other attorney about the case and the facts, and, if their role is an expert, I mean, obviously, maybe it's just worth repeating that they need to be aware of those issues and cautious of the fact that they're not acting in the role of an attorney and
be clear. I think the ABA opinion is helpful that way. It basically says, you're responsible for making sure that people aren't confused. And I feel this how far we want to go with this, I don't know. But whenever I'm consulted as an expert now, I feel like that's almost the first question I want to have. Is do you want to just consult me? Do you want to testify? Do you really want my legal advice in this situation? Which role do you want me to be in? Because it's really hard for me to play both.
Yeah.
And I don't want to get into a situation where down the road you say to me, I'd really like you to be the testifying expert, and I have to say to you, that's
Right.
such a bad idea.
Exactly, right. No, I think the articulating those three different things, do you
Right.
want legal advice, do you want me to consult, do you want me to be an expert, is a good.
Right.
But my only concern is I don't draw the line. There's many legal experts, and I think this is a point Adam was raising in maybe in the legal malpractice context, where the law firm is hiring a standard of care expert, initially as a potential consultant, potentially as a testifying expert, and I don't think just because that standard of care expert or consultant is providing legal advice to the firm renders that an attorney-client relationship, doesn't result in an attorney-client relationship for purposes of the rules applying.
I agree
I think
with you.
I think-
So I don't think we can draw it like so strictly as between factual versus
Well,
legal
advice versus interpreting the law, right? You're.
All I can say is if I were a standard care expert, I would want to be clear, right? And I'm brought in on a consulting basis. I'd want to be clear that I'm a consulting expert and not a lawyer.
Yeah, and I think it's important that, in the opinion too, that it address the disclosures that should be made in the engagement agreement itself, making it clear that you're not entering into an attorney-client relationship.
Right.
Right, because there can be a difference between the outside consultants that maybe your firm hires providing you legal advice versus telling you this is how I would interpret the law, which may not necessarily be legal advice. It just may be this is my view of this particular thing. I'm not telling you what to do. I'm telling you what my, in that context, right? They're not saying the firm's relying on them for advice on how to act, but just saying my interpretation of these things is.
I think telling California lawyers that if they're acting in a capacity other than a lawyer for a client, then yes, they have to spell it out and make sure that everyone's clear on what their role is. And
Right. I
Yeah.
think that may be the
And that's on
answer.
that.
Yeah,
That may be
yeah.
the answer, is that if you want to be sure, if you want to be sure that you're going to be able to take advantage of the argument that you're not a lawyer, you better be clear about it from the start.
I also think that acting as a lawyer, I have trouble with that term too. It's not just purely providing legal advice. There's that, the case with employment law investigators, I'm blanking on the name right now, where even when they're merely providing factual, doing a factual investigation, they're still considered to be in an attorney-client
Right,
relationship.
and that's why it would be super important to be clear, right?
Yeah.
Because it's so easy to get drawn in, which is very consistent with the ABA opinion.
Yeah, I
which
think that's
basically says-
has to be the main point, is that they need to be clear.
Right.
And at the very least, it'll get people to think about it, like you said, before you enter into these types of relationships, what is the relationship you're entering into?
And I've had that conversation with a lot of other people who serve as experts.
Yeah.
And particularly people who do legal ethics talk about it.
I don't want to beat a dead horse. I'm curious now. So if somebody comes in the door to me and they have a patent infringement case, and I have the foggiest idea how to prosecute that, no clue. And I look at them and this person says to me, hey, I think I was wronged and I've been damaged by $3.5 million because my patent should have gone through or somebody stole it or whatever happened. I was like, I've got no clue. But I know a good patent lawyer over here. So why don't you hire me to do an investigation? And then I hire this person to tell me whether something was wrong or not. And I go hire, Joe, the patent lawyer. Are we saying that Joe might have an attorney-client relationship with my client and duties owed to my client? Is that a suggestion that's even a question? Because to me, that's not even.
It depends on what the contracts say.
What
I think that
The contract between you and the expert.
So you think the expert and I can contract so that, by the way, you have an attorney-client relationship with my client now?
I think you could fail to say things in the contract which cause that to happen for sure.
You do?
Yeah.
So that premise,
If you had a
disagree
meeting and the two of you sat down together, and then the client maybe would think. There could be an implied attorney-client relationship that you would want to make it pretty clear that they were not acting as an attorney and they were acting as an expert in that situation. They were not providing legal advice or.
Personally, I'd probably rather have them be the attorney, right? It seems
Well,
to me
but that cuts against your point, right?
Well, no, but what I'm saying is I
Which
don't
is
think-
that you may be in fact piggybacking on their legal advice to do all kinds of things with respect to putting together your case.
Well, of course I am, because I don't know anything about
Well, okay, but I think that the more you say it, the more it sounds to me as though if you aren't very clear with the expert about what they're doing, the client will have an argument that they are.
See, I think the only reason I'm hiring that expert is not to prosecute an underlying patent. That issue is over. I'm looking to them for literally a factual issue on the question of breach in a subsequent action.
Yeah, but it just doesn't, that's a hard line to maintain unless you make it very clear that that's what you're doing.
And maybe lots of
And
times.
unless you know about the substantive law, underlying substantive law, the harder it's gonna be for you to argue that they aren't a lawyer too.
So to prosecute any legal malpractice case, if I'm not an expert in the law, I'm essentially gonna have to hire 2 different lawyers.
No.
One to be a consultant to help me, and then after I get through that consultant, who may or may not own attorney-client privilege for the client, then I need to hire somebody else
No.
to do the same thing as a testifying expert.
No.
No.
Well, I'm just.
No, I mean, every expert witness engagement letter I've seen, including my own, specifically disclaims an attorney-client relationship. And the lawyers certainly have a duty to tell people who might be confused, hey, I'm not your lawyer. I think the consulting expert is not an attorney, but is a person that comes within the exception and the privilege for third parties necessary for the representation. So it seems to me, the issue to me seems pretty clear.
All we're talking about is a disclaimer that that person that you hired, that patent person, would just need to make it clear to you that there's not an attorney-client relationship between you and that patent attorney, or between your client and that patent attorney. And then you could have that one attorney,
right.
And you would be cautious about what information you gave to them, knowing that if you did want them to testify, you wouldn't want them to have confidential attorney-client information that they would be obligated to, turn over their entire file and is the basis of, information that you weren't willing to share, that wasn't relevant to prosecuting your case, discoverable information that you wanted to share.
And in addition to that, depending on how you arrange the relationship, you might result in a reasonable inference on the part of the client that the consultant you brought in, the expert, is his or her lawyer as well, and then you create an attorney-client relationship between the expert and the client.
Because some people do hire people, I wouldn't say it's co-counsel, but another attorney, another area of specialty to absolutely give them advice on that idea, and then if they ever had to go to trial, that person that specialized in that field would maybe help them find a suitable expert on the subject, that they've been educated and given advice and related to, that particular subject matter, and that's helpful. But that's just a strategy decision. It's probably a cost decision. There's a lot of decisions that go into, in most cases, you don't want to hire the 2 people like you're talking about, right? So it's just a matter of that IP attorney's obligations to disclose based on the potential for confusion. I think that's just what we're.
I understand. I don't think I'm disagreeing with anything. I just don't think that my factual scenario is going to turn on whether or not, in a fee arrangement with me, the IP lawyer writes, I'm not your lawyer. But the client might not ever see that. I just don't.
No, you'd have the ABA opinion actually talks about this and says actually the lawyer for the client has an obligation to make sure that the client understands what this person is being hired for. And it's also fair to say that in an abundance of caution, if I'm the expert, I might want to say, I assume there's some very interesting opinions on being a local counsel, right? Where this issue comes up because the law firm that is out of state wants to hire local counsel, and there's ABA opinions, I think it's ABA opinions, suggesting that in that situation you'd be foolish not to get at least a representation from the lawyer who hired you that they've gotten the client's consent to your hiring and that they understand what's going on. And the same kind of thing might be argued here.
I don't disagree with that at all.
But this is the same kind of thing. If I'm an expert, I might want the ABA opinion says you can rely on the lawyer who hires you to tell the client whatever limitations you impose, right? But the belt and suspenders approach would be to say, here are the limitations, and I understand that you are going to convey that to the client.
I use that belt and suspenders approach, and I still encounter confusion on the part of both lawyers and clients as to what my proper role is as an expert.
Yep.
So I often have to have clarifying conversations to be something like, yes, I know you want me to tell you how to litigate your case, but that's not what you hired me to do.
Right, and like you said, Adam, you don't typically let, for example, those consulting experts talk to your client. Like you know, sometimes as like experts, you do find yourself saying to attorneys like, you know, only give me information that you're comfortable with being discoverable, that is going to be discoverable in proceedings, like depo transcripts, right, declarations and things that they review, and because of that, because you don't want a situation in which, you know, that's going to be implied, or you wouldn't sit down in a conversation with the client, the consulting expert, without, I would think, a very clear statement that attorney-client privilege, you know, doesn't apply between the two of you, and if you end up being disclosed as an expert in the case to testify,
This is, I think that, I don't know that we've got a full answer, but I feel like the framework is there for that issue. Are there other issues that people are concerned about?
I have one issue in the analysis about the Shepard-Mullen case.
Yeah.
You focused on some language in it and implied that it's maybe no longer good law.
No longer a good law for the proposition that the rules of professional conduct regulate that.
But I read it differently than you, and maybe I'm not, but
that's totally reasonable, by the way.
the sentence you're focusing on is the application of Rule 3310C does not require representation of both clients as an attorney. But in the Shepard-Mullen case, it involved a situation where the attorney was first representing the party as a lawyer, and then went in the same case and testified as a PMK witness. So,
right, exactly.
I do think in that situation, it's clear that the lawyer owed duties.
But they're by virtue of having been a former client, right?
Yeah.
I totally agree with that, and I don't have a problem with in that, but that's not what the Shepard-Mullen says with respect to 3310. It says that for purposes of 3310, the acting as a PMK is covered by the rules of professional conduct.
And where do you, is that like, I thought you were focusing on the language you quoted on page 4. I haven't looked at the opinion recently, but I was just looking at the language you highlighted here.
I may be reading it, let me say, I find that opinion quite confusing. And I may be reading it wrong, but I read at least part of the opinion as saying that acting as a PMK witness, right, was equivalent was covered by a rule which only applies to representing a client. Right? And that struck me as a potential fly in the ointment for the analysis we were putting out, even though a PMK witness is not an expert witness, and even though there's no showing that the PMK witness actually, in this case, disclosed, but didn't make or didn't make the kinds of disclosures we would have talked about.
Maybe then it's not helpful to have it. I don't know.
Well, I'm not sure we're going to discuss it in the opinion.
Okay, you just want context.
I wanted to flag it because it's an issue, not because I think we necessarily need to discuss it. It's fair to say that the Ruthergard Treatise does not feel the need to deal with Shepard-Mullen in this context, and we might not feel the need to either, or we might want to just distinguish it 3 ways by Sunday and not discuss it at all. But I'm just saying that language gave me pause, and I had to work my way through it and find out why it didn't apply. There are other ways to read Shepard-Mullen. You know, the Raley case is also a problem here, right? The Raley case is the case where I think it's the Gray Carey firm is representing a plaintiff against the Raley company. The Raley company is in trust, shares are in trust. and a partner of the great Harry Firm, sits on the board of the,
Yeah.
right?
I view that, I still, yeah.
That case was decided by a very distinguished judge, but on the basis of a version of the professional rules which no longer exist, which forbade representing conflicting interests. So they were able to apply the rules of professional conduct to the corporate director, right? And that same analysis was used in the Shepard-Mullen case, representing conflicting interests, which is arguably a different and broader standard. So there are a lot of ways to walk away from the result in Shepard-Mullen. And I want to, but we can talk later about
Yeah, I'll have to, I want to look at the language that you're focused on.
Right.
Those things.
That language gave me pause, and it may not,
yeah.
it may be that there's no reason to worry about it at all. I'm perfectly open to that.
No, but right, as you point out, as a PMK witness isn't necessarily an expert witness.
Exactly.
Yeah, so.
But there are a bunch of arguments.
Yeah.
There are a whole slew of arguments that could be made. I was just being super careful.
Yeah. I just have one comment that I don't think we should mention the word fiduciary at all in this meeting. No, I don't want to suggest that an expert witness is a fiduciary. I don't want to suggest.
I think it would be, that would lead to,
I have one.
if you took it literally, it would lead to catastrophic results, right?
Although I think one thing that would be helpful is to clarify in the engagement that the lawyer, not only is the lawyer not entering into an attorney-client relationship, also the lawyer is not acting as a fiduciary. That might be a good disclaimer to have in your engagement.
I don't know if you can do that.
I mean, but do you think every expert that you hire is a fiduciary? I mean.
No, that you're not acting as a
fiduciary. Right, no, I know what you're saying, but I mean, I wonder if that's necessary.
It's only necessary if you think that every agent is a fiduciary. I don't think the case law goes that far, right? I don't think it goes that far, and I don't think that that every agency relationship gives rise to the risk of confusion that would justify that kind of rule. But it's worth.
I'm just hesitant to even remotely weigh in on that.
I'd like to say, you can tell, I'm raising what I think are these are the things that worry me, right, in terms of, but I basically think that subject to some of the issues we've discussed today, the conclusions in this opinion are pretty strong.
Yeah.
Brandon, are you still there?
We are.
Brent, you mentioned, I think you had mentioned, or maybe it was just your very good letter from the LA County Bar on this subject. But I'm wondering, do you have experience that would cast light on any of these issues?
I do not. No, that would be some of my colleagues at the LA County Bar. The former chair, the immediate former chair, does only expert witness work and is very dialed into these issues. So that wasn't my personal insight.
Okay.
Whatever you're remembering.
Would that be Neil?
Yes.
Yeah, okay, because he's written an article about it, but it doesn't get into any of this stuff, as far as I can tell. It judiciously avoids it. So, all right, that's helpful. Okay, is there somebody, I'm looking at both Adam and Sarah. I'm wondering if either of you would have any interest in carrying this opinion forward or not. And I don't think either of you are lead drafters on any opinions right now, right?
Correct.
Right?
I'm happy to. I'm happy to. I struggle with the need for it. But I'm happy to work on it and see what I can do. I mean, I think I've made my points on it. It's just too.
Well,
yes, I would like to work on this opinion. I was going to join it. I just have. I think it's more black and white than we have been talking about today.
Okay. Well, you'll get a chance. You'll have if that view is right, you'll have a better chance of advancing it as the lead author.
And I'm happy to help you out as well.
And I'm happy to stay on the drafting committee because of my interest in some of the underlying issues. But
I think David Carr is also on the committee.
David?
So it could be the four of you.
I am on this committee.
All right,
Yeah, and just that, I guess if we're gonna do it in an opinion, maybe that's true, but I also think Adam makes a good point that if we ever decided to put it into opinion, I don't know if we have decided to turn it into an opinion, but if we feel that it is, based on the further analysis, more straightforward, if we want to consider an article or, I don't know, another avenue for addressing
well,
this issue.
let me just,
Unless we're pretty firm.
so one question is, do we want to turn this over and let you guys, I'll turn it over to you guys and let you guys come up with what you think a better outline for the opinion would be?
Okay.
And it is very much the case, right, that no one is obliged to continue the anxiety about the Shepherd Mullen case, right, or the anxiety about the fiduciary doctrine, right? Those don't seem to me, we have a sense that those are not, those may not be central issues for us here, right? And and with that, shall we say that you guys will do a sort of a more detailed, or maybe even more a skeletal issues outline?
Yes,
Right,
I
that's
would-
clearer than this and focuses on some of the issues we've talked about today.
Yes.
I mean, it seems like we can have a short opinion, right? I
Yeah.
mean, we're capable of that, right, Andrew?
It's been a while.
They're allowed under
It's just
15
you could-
pages?
Yeah, but I mean, you could just focus it on those issues of like, okay, you're not in an attorney-client relationship, so you're not subject to the rules related to, you know, specifically only that address your duties to clients, and then need to disclose those issues and.
Yeah, look, we agree on the outcome, so
Yeah.
I will, yes,
So,
with the caveat of it's not next time, because I don't think I'm gonna be here for the April meeting.
sure.
Okay?
I would just offer some just general observations. One is, as you consider developing this opinion further, how broadly applicable will it be to the practicing community? And then two, although I will say as the further discussion occurred on this topic, I was a little less concerned. But the second issue is I want the committee to be attacked as being lawyer protective. And so there were some interesting discussions that we had with respect to disclosing to the client, not for the fact that the rules wouldn't apply, but to help protect the client with any misinterpretation about how the expert was acting or what the expert's role was in the retention. Those type of things I hope will help, if they're able to be added to the opinion, will help insulate the opinion and hopefully not make it too long, because I agree with you, Dina, we don't need a lengthy opinion. Those are just observations and concerns I have, the way I heard the conversation.
So that actually raises an interesting question, because I suppose we don't need to write this only as the ethics of the lawyer as the expert, right? Couldn't we add in the ethics of the attorney retaining the lawyer as the expert? Because to me, that has more meat to it all. I mean, if we can do both, and I assume nobody's gonna argue we shouldn't do both, I hope.
No, I think that's interesting. That occurred to me when you were talking about it too, yeah.
Okay.
Well, what specifically are we talking about though in terms of the attorney's obligations?
Well, so
I'm worried about it getting pretty sprawling if you would take on all the ethical obligations of an attorney retaining an expert.
And I don't think you need to get on all of them, but I think the point that you were making is make sure the client, when Steve, you were mentioning the client needs to be aware that the expert isn't the client's attorney.
Right.
I don't think that's the expert's job to deal with.
No.
To me, that's the retaining lawyer's job to deal with.
And the ABA opinion is very good on that, and we could put a California footing under the ABA opinion's conclusion too, on that.
I mean, I haven't read all the background sources.
No, I of
so
course
I'm
you
gonna
haven't,
need
and
to-
I'm not trying to see it, I'm just saying that the ABA opinion has a really nice discussion of that, that could be easily translated to California law.
Yeah, I guess one way to think about it is how are we framing the issue? Is it what is the expert attorney's obligation to the client, which wouldn't be correct because the way we're formulating it, there is no relationship between the expert witness and the client, right? Part of the conversation
I think we're asking
no
something like,
attorney-client relationship
how
is created.
the ethical rules governing the practice of law apply to the work of a lawyer expert witness, something like that. And
if agreeable with
the
this.
answer is something like, they don't really apply if the lawyer is sufficiently clear about what they're doing.
Right. And if I'm not saying that's incorrect, then my
And then the
concern
quote-
is again raised, how
To
valuable
avoid
is this
confusion, the
opinion?
client should be made
Then-
clear
and
to
then
the client that they're not acting as a lawyer.
Unless we add in that component of the opinion.
Right,
which
and
are
I agree
helpful
with, and I
to-
agree that component should be added in.
Because otherwise you're talking to only lawyers who serve as experts, which is.
And you're concluding no duties are owed.
You don't know anything?
But lawyers that hire experts are much larger.
Right, I agree.
Yeah,
Yeah.
so I like that idea of, I mean,
Right.
we could do both, and I don't think it's a lot of.
I mean,
I'd
I don't either because.
I'd almost flip it, I would say, what is the obligation of the lawyer that hires the expert first, and then as a secondary issue, what's the expert's obligations? And if you appropriately engage in the relationship and make the appropriate disclaimers and disclosures, and we'll discuss that, perhaps the rules don't.
Because to take it one step further, and this is what, if you hire a attorney who is going to provide legal advice and work on the case with you as opposed to fact expert, you're now getting into 1.5.1 fee sharing, or COPRAC has an opinion on contract attorneys and your ability to hire outside counsel and work on the case. I mean, that's what, you're either hiring a lawyer to work on somebody's case or you're hiring a fact expert, right? It's one or the other, I think.
If you, the attorney, are doing that, right? Like sometimes clients will wanna hire another attorney to get, you know, so.
Well, that's an attorney.
Yeah.
If the client hires the attorney directly, that's,
Yeah,
there's, so I guess we can set out those factual scenarios and say, look, this is.
There's also cases where a lawyer hires an attorney to make a special appearance, and the court concludes the special appearing lawyer owes all the duties to the client.
Right, I'm just saying, I'm not sure.
Which is not helpful.
How far we want to get into the question of what, of all the duties of the hiring lawyer.
Well, maybe they can work on an outline and
Yeah.
figure out like the scope, and then we can talk about it. If you
Right.
think when you do the, analyze it, that you guys think like, okay, this is gonna be too much or too long, and we need to
Right.
really have these separate opinions, then.
And I recognize what I'm suggesting is different than what you're proposing, Stephen. I don't mean to change it, I'm just raising the concerns for the group to consider. It's not
Right,
you have
and
to
then
go
that's fine, and if the bigger project makes sense, that certainly is, something the group can decide, for sure. Yeah.
I just worry about.
Adam, thank you
the
for
narrow-
taking this on, that's great. All right, succession plan.
Are you my champion, Andrew? All right, I know it's getting late, so we will, I don't know if it's getting late or not, but it seems like it feels like it, right? You hopefully have reviewed the memo. I think it's a really, really important issue, because it affects all lawyers. I think obviously it disproportionately, clients' rights are much more imperiled in their interests when they engage solo practitioners or small firms if there's not these protocols in place. And so the question that I'm just kind of wrestling with, and I laid out, a bunch of rules that are potentially implicated by issues related to incidents that could happen to attorneys that would render them unable to continue to represent clients. And I think the biggest question that I have sort of for the discussion is just to decide how comfortable we are with, sort of saying that they have, lawyers have duties to engage in succession planning, right? Just sort of like, are we gonna say they may have a duty to do that and outline it? I don't wanna, I again raised some arguments here regarding the diligence rules. There's a lot of jurisdictions, and more than I even included in here, that have either a comment 5 to their diligence rule, or in South Carolina's case, their own rules. Some jurisdictions have, as part of registration, for their individual state bars, they have to sign something saying that there's a surrogate attorney that they're gonna be using or a proxy. So there's a lot of different jurisdictions around the country have handled it differently. In California, there's not a comment 5. There's not a separate rule requirement. We could kind of interpret some of these rules here as implying an obligation. I certainly don't want to be in a position where we're interpreting rules or, that are not, and interpreting language and intent that's not meant by the rules themselves. Sorry, I'm not very articulate at this point in the afternoon. But so I want to be mindful of that. I mean, I think, one of the analogies, of course, is this idea that, like, okay, if you went on vacation or you're planning to retire, of course, I think we could all agree that you would have a duty to make sure that your client's interests are protected while you're gone, whether that means making sure that, like, another lawyer in your office is handling that, or that you've moved court dates, or, and such. And then the question is, like, can that sort of analysis and consideration be applied to a situation that, succession planning, which these incidents, like, could happen to anyone any day, but most people don't view them, and particularly if maybe you're younger, and sometimes if you're older, as like an imminent threat or risk of happening, or a likely event to happen, so people don't consider them. And I think that it's a particularly problematic situation for solo practitioners, obviously, or when you have, like, maybe partnerships where they're small firm partnerships where people are kind of siloed off and do their own thing, right? So, and particularly when those individuals are also involved in managing a law firm, right? You don't have some other person at the law firm that's basically in charge of all the passwords or has access to an IOLTA account. And so there's a lot of issues that I can, like, hopefully other people will join this committee with me and help flesh out those issues in terms of, like, best practices. I know we don't really do best practice type things, but it's certainly, I think, important to identify all of these issues that are critical, because it not only impacts clients' rights and it tremendously, but there's, like, this sort of burdensome aspect, I think, that it also has on the courts, right? When you have a situation where you have to apply under this B&P code to get, an estate has to get permission to have someone appointed to handle the winding up affairs, and meanwhile you could have clients out there who are like, I can't get access to money in my IOLTA account. I don't know what's happening with my court date. I can't get an answer to this. Nobody can open this attorney's computer and get into their files because we don't have access or authority. So this is an important issue. I think also with, the aging population of the bar too, that's something that is more important for that generation to consider, although everybody should consider it, but, like, there's more of a likelihood that one of these events could occur that would impact those attorneys. And so from a client's rights perspective, it's really a critical issue, I think. And one that maybe not everybody thinks about all the time. It's sort of like the life insurance policy thing where sometimes young people don't think about that, And in any event, not to be too preachy about it. So I guess the real question is what you think of the outline and the approach that we should take to putting together an opinion on this, if you agree that it's valuable to pursue.
Are there any local bar opinions on the duty to, I'm sorry. Are there any local bar opinions that you're aware of that touch upon this issue?
I know I looked at that issue, and I didn't find any opinions. I mean, I think there are and the ABA has some specific opinions about, okay, what happens with the death of an attorney and how you, like, wind up the law firm. And there's some of these opinions we can talk about in more detail related here, but, like, there's not an opinion that says, any opinion that says affirmatively anyone has a duty to kind of plan for these things.
I guess I can see how we can conclude that such duty may exist based upon the existing rules, but I'm not sure how comfortable I personally feel saying that we have an affirmative duty, each member has an affirmative duty to engage in succession planning. I don't know how other members feel about it.
And that can mean a bunch of different things, but let's talk about that, like what we're comfortable. I mean, I agree. I don't want to make a conclusion, draw a conclusion or write an opinion that states that attorneys have a duty that's just not present in the rules, and they can't arguably be present in the rules.
Mm-hmm.
Yeah, I tend to agree with what Amber said. I feel a little uncomfortable about it too, particularly since you pointed out, many jurisdictions have adopted comment 5 to the diligence rule that indicates there might be a requirement in certain situations. And I think it's really dependent on the facts, and I mean, we could address it, but I guess I don't know, being a little bit newer in terms of our protocol, can we do something other than an ethics opinion? I think provides very good guidance, the set of information for attorneys, particularly small law firms and solo practitioners, but I feel like it would be good as like an ethics alert.
But then that would be more like a best practice kind of thing.
I mean, I think there's a lot of interesting questions that are raised by it. Like if a client hires some person that an older person who's a solo practitioner to do some, do you think that the client should be informed if that person has no succession plan in place, or that there's a risk that like if they hire them that for a court hearing in a couple months that there's some basic competency and duties that it's sort of like, maybe there's certain circumstances under which they would be obligated to prepare, a plan for the eventuality of some of these, that they're unavailable to assist the client, for example. That's the struggle, obviously, that's the issue, is sort of like what we're comfortable saying. It could be more of just a general best practices ethics alert type thing, and then the question is like, well, is that gonna get the same kind of attention and that it needs? I think it needs eyes on it. I think that conversation needs to be happening, and I don't know that, from every aspect of like, when we think about small firms and like how you practice law and passwords and who has control over is there one person that has control of an IELTS account? Just more than one person? Is there, these types of things that I think are, in feral clients' interest and are really critical. So, I don't know how many people are, still here to opine on it and how we should approach it.
You pointed out, I really like the outline for the discussion part, and I agree with all of them, but how do we frame it?
Yeah.
But how about if I put the other way? Suppose that a lawyer, suppose that bloomer lawyer like me has a solo practice, dies of a heart attack, and $2 million case is not filed because nobody could sort out what's going on in time to make sure the statute of limitations, right? What's the defense against the claim that, supported by expert testimony, that any reasonable lawyer would have established some means to make sure that in the event of their untimely demise or illness, that these highly consequential matters would be taken care of? Does the lawyer have a defense to that? What's the argument that it meets the standard of care?
So is that claim brought against the lawyer's estate?
Yeah.
Sounds awful.
Yeah.
Sounds like, and basically against the lawyer's insurance company, right?
Yeah.
There doesn't seem to me like there's any defense to that claim. Of course you should have a succession plan. Why wouldn't you? Except you haven't thought about it.
Well, right, and that was like my again, not that you have to tell your client
yeah.
everything about your practice. No, it was good for you to chime in, but I was thinking that same concept where it's like, would the client want to hire you if they knew you had no such plan in place?
Right, it's
right?
a little like not
they,
having malpractice insurance.
Yeah, right. It's like that's an interesting.
But it suggests that we're not doing lawyers a service by suggesting that they have no obligation to do this. That
right.
This is just a good, nice idea they might want to think about. And I'm just playing devil's advocate here because very sensitive to. One question would be, can we just, is it so clearly, well, I mentioned this already to you, Dina, I think that there are some maybe opinions, like the one about disasters.
Yeah, I read that, I kind of scanned through that while we were here, I didn't really think that
it says,
was as helpful as I thought on some things, but yeah, I think.
But it was basic, but it was clear that the lawyer has an obligation to plan for the foreseeable risks of a disaster.
Yes, that concept I think is.
Right, and I don't, analytically, it feels to me like
Yeah.
this is very closely analogous to a natural disaster.
Yeah, and I was thinking of that same thing. I just pulled up, because I recalled, I was trying to remember what, I thought California, the state bar, they have a website alert for attorneys on how to prepare for disasters. Which I remember looking at that connection previously with the ABA. But
What is the website? How does the website frame it?
it's regulatory, well, I don't know, Andrew might know of another one, but what I'm looking at is the regulatory information for attorneys impacted by the California fires. And then it talks about ethical obligations, how the state bar is warn the public, and then it goes into the applicable rules, and steps to take, has a bullet point list of steps to take, relevant ethics opinions, insights too, and then other resources.
Is that under the senior lawyer resources? No, I'm trying to.
No, it's
somewhere else.
it's under let's see, public need legal help section.
Legal help after a disaster. It's under the public section. This is for lawyers? This isn't for lawyers. The one I'm looking at is not for lawyers. Oh, no. This is for clients.
Yeah, disaster legal assistance, yeah.
I thought there was a section though, because I worked on it.
Well, the one I'm looking at talks about the ethical obligations of the attorney. Refers to a bunch of resources for the attorney. Yeah. I can forward it to you.
Yeah. Yeah, I mean, I think that's a general analogy. It's sort of like to prepare for, to protect your client against these. I don't know if I would call them unforeseen, but unplanned events. Yeah, I mean, the ABA's, the ABA website, which I think I linked to in my, well, you can't pull it, on the article, has like a pretty good resources.
Here's something also, the State Bar Surrogacy Program.
Yeah.
That's under the senior lawyer section.
Yeah. I mean, they have that template that they have on the website that's basically like for the future, like the surrogacy, like future sale of law firm, basically like where you say you're handing over your.
Yeah, emailed you a link, so it might.
Steve, to follow up on your example about what would be your defense if you die of a heart attack and as a result a $2 million case doesn't get filed, right? But wouldn't that be a standard of care issue, which is different to me from
I'm just worrying about
obligation.
my point is that if we're worried about legislating a standard of care issue, right?
Mm-hmm.
And in fact, we conclude that a lawyer in that kind of case would have no standard of care defense, then we shouldn't be too worried about saying that there's an ethical obligation to do something about this, right? In other words, we're not, if the reality is that a lawyer would have, the lawyer for the lawyer's estate would have a very, very hard time explaining why it met the standard of care not to take these precautions, right? Then maybe we're actually doing a service to lawyers. We're not exposing them to any risk they're not already subject to, and we're at least explaining to them that they ought to be thinking about this in terms of their ethical obligations. That's all I was trying to say. I'm not trying to say. I mean, I guess my instinct is I never thought of this before, but now that it's been brought to my attention, I can't imagine why it's not an ethical obligation.
Well, one thing that's weird is, one challenge, a lot of ethics opinions are framed as, what duty does a lawyer owe to a client to have a succession plan in place? As we're talking, it's difficult to find one in the rules, even the State Bar Act as they're written today. The other thing is, should the lawyer pass away and fail to have a succession plan in place, no discipline is going to be imposed against the lawyer in that example. And third, ethics opinions don't typically aren't structured as best practices.
Right.
I can't think of one, but I'm certainly will do some research about ethics opinion, which has like a quasi disclaimer at the front and says, this isn't.
I mean,
I don't know how to do it, but just to concede the fact that this ethics opinion's purpose is to raise issues and provide guidance and best practices, or however we want to word
right.
it.
I mean, another option would be,
the reader.
yeah, to say like under certain circumstances, an attorney may have ethical obligations to, like basically say that they might have them. I mean, and that's not very. No one's going to be disciplined for not having it, but you're basically saying like under certain circumstances, and we can have a fact pattern that was like some extreme circumstance where
Right.
it appeared like,
That's the other thing, you wouldn't want like a random audit to be sprung upon some lawyer and says, based on this 2020 ethics opinion, can we please see your succession plan you're supposed to have in place?
well, I mean, already like malpractice carriers, I mean, a lot of them you have to identify who, if you're solo, they say, or if you're solo, who's your surrogate?
Well, that's good.
Some of them do.
Yeah.
Yeah, not all of them, but some of them do.
Anyway, those are things that come to mind, but this would just be so valuable, particularly the discussion on Rule 1.15. So many solo practitioner, banks are reluctant to allow access to those accounts. Very difficult. Compliance takes a long time sometimes to get that unwound.
Right, because you basically have to go through court to get
Yeah.
permission to get access, and banks are not
Yeah.
gonna,
It's very challenging. Anyway, those are my observations.
I mean, and then there's issues that identify like ethical duties that, if you were gonna agree to be a surrogate person, that just the things to think about, like what would your role be in conflicts issues and, whether you would have the attorney-client relationship, whether you'd be representing that client as a surrogate, or you just be, your purpose would solely be to help wind up the office, and then what.
What happens when that surrogate attorney has a conflict and can't file Steve's $2 million case?
Right, or like confidentiality issues and things that could you learn information, and then is that if you're not acting as the step-in attorney, and you're subject to confidential information, and is that somehow, is that still confidential attorney-client communication because you're not in that relationship, right? Is it subject to that?
This is such a good opinion, and it does seem to me that maybe, does it make sense that I'm trying to find can I just look at it feels like the language of some of these out-of-state rules, right? The duty of diligence may require.
Yes.
Right.
Right. That may be the perfect framing,
Lawyers
right?
should prepare.
Thinking
Yeah.
about it, right?
Yeah.
May require.
Yeah, I mean,
If that's a good enough for a comment, it could be good enough here, because once we get it out there, right, it'll have
yeah,
a
I mean,
ripple effect.
right. That's maybe the path to go. I mean, because then that's just as I was saying,
The
the
hypothetical the hypothetical you come up with does require
right.
a succession plan, and so it would be couch the analysis as a may, such as based on these facts,
Right.
a succession plan is necessary.
So I think that's as far as we can go. I think even the ABA opinion on disasters, when it comes down to, it makes it, and there is an analogy in there related to succession planning, and they have some footnotes, and but I think the word they use as well is the word may, because that's what the comment says. So
Do we need hypotheticals? Can we do without them and stick with the
under certain circumstances, you
Well-
should, or you may, or say, look,
I
no,
mean,
it should.
Yeah, I mean, we could say a hypothetical could be like, you know, a solo practitioner, advanced state, whatever, is wondering if they should have a succession plan, and then it's like,
Say, yes, you should.
He's 88.
well, they're wondering what obligations they might have to clients in the event of, like, you know, one of these things happening, and then we could say they may have obligations, you know, I mean, our hypothetical, which we've employed in some situations, like the hypothetical facts can be a very, like, one sentence,
Yes.
right? Like on the departure one, we basically had the person is leaving and they want to know what their obligations are. And
Right.
Yeah, I kind of like it being broader though, in this situation. You know, if we hypothetical as solo practitioner.
Yeah,
but
yeah.
I kind of like the idea of, I don't know, just addressing, making it generally applicable. I know it wouldn't necessarily apply in the case of a large firm or a young associate, right? But we can, I just, if we focus on.
Well, I mean, firms would definitely have like, I mean, if you think about, I mean, again, in most large law firms, it's just not really gonna be much of an issue, but they obviously should have practices and policies in place where they make sure that you don't have like the attorney who's in the corner who's not saving their stuff in client files and who's not like following protocols, and if something happens to that aging attorney that no one can like figure out what's going on. Now, they have a lot of attorneys that can probably step in, but they obviously need to have protocols in place where they're tracking what cases and they're you know, the matters and the retentions are who and how are their staff, which I think most firms do, and that's less of an issue, but it's maybe worth identifying, you know.
I was gonna say that maybe, and this is, I think, consistent with what everyone's been saying. I like the idea of doing it, making it a solo practitioner, because that's the strongest case. Because that's the obvious case, and the principles will, again, have implications for other people, and thoughtful people will look at it. But I think that the goal here, I mean, I sort of see this as something that somebody, like Dina, you would, or whoever's drafting the opinion would be out there at the CLA Solo Summit, for example, right? Somebody would do a presentation on this opinion, and it would really wake a lot of people up.
Well, I mean, go ahead.
Well, I was just going to say the advantage to that, I take Sarah's point about it, the concern about being narrow, the advantage to, I don't know, 88-year-old attorney, solo practitioner, has last 6 months had a couple mini strokes, but you know is still cognizant and doing well. If some framing such as that we can justify the duty of competence, due diligence, and the cases that he has justify the need for a succession plan. Maybe we don't have agreement around the room. This I'm just talking out loud. And then so that sets the scene. And then the analysis includes, similar to the you know, using Wi-Fi at a public location, some of the best practice techniques where you list all the things we should do. Right. And that type of framing would have wide applicability, and you hopefully the reader wouldn't say, well, I'm not 88 and I didn't have many strokes the last within the last 6 months, but I'm 40-something, 50-something.
Any attorney should evaluate their duties under these.
And here's a great ethics opinion which really provides detailed, helpful analysis and guidance, and that could be of broad application, notwithstanding the fact that we need our unique fact pattern to justify.
And you want this opinion to be called "Okay, Boomers"? Is that what you said?
That's what I wanted to call it. I think that's the panel. That's the panel title, right?
It would be distributed
Okay,
far and wide, and you know, we're just anecdotes, but the attorney population is aging, and really be great. Notwithstanding the fact that I totally recognize there's a challenge in how to frame the issue and apply the rules. And
No, yeah, I mean, as we're talking, it's shaping up, at least in my head. And I actually like Dina's hypo the best, which was simple and without too many details, because it oddly, it's
you like mini stroke.
it's specific and broad at the same time, because it's so clear that it would apply, but then there aren't enough details to kind of make your brain be limited in how these discussions would be applicable. So anyways, that's
Well, I could play around with like you know, like whatever, a more narrow hypo or a more detailed, we could kind of, I mean, I think the more we're talking about it, because I do want it to be an opinion, you know, and it's trying to find the right framework without, And I think saying that they may have obligation, like, I think that's a good formulation of it. And then people can, because again, we know this isn't gonna be a disciplined opinion, but it's just really about getting the word out of like thinking about what you're doing implicates your clients' rights and their interests and that they're. Yeah. Well, and I mean, not that we would necessarily get into this, but like you mentioned that like the estate issue and the lawsuit, I mean, it has all kinds of implications for the family of that attorney too, right? Because what happens then, the family has to take care of it, pick up the malpractice cases, has to, their interests aren't protected, and is their insurance to, it is. Yeah, it's not a good thing. It's, so.
I wonder if Brandon and David.
Brandon or David, do you have any comments? Are you still there?
We are here. I have no comments.
Do you agree with the direction we're going in?
I have some concerns about, as a matter of civil law, it may be the case that an attorney who dies on the courthouse steps before filing the pleading has no defense. I'm not sure about the ethical violations. So I have some qualms, but they are not specific enough to be helpful yet.
Okay.
I have some qualms as well, and I'm not sure how to articulate them except to say I think there's a reason why these other states have looked to adding a comment or adding an actual rule that clearly lays out the succession plan as an element of competence. To me, it's not. I don't find it self-evident from Rule 1.1 that a competence plan is required. So I think I need a little convincing on that score. Certainly it's best practice, and I've never been shy about erasing the distinction between ethics and best practice, but it seems to me a little bit of a stretch to take the competence rule and say that now requires an attorney to prepare a succession plan. And in terms of discipline impact, if you say the rule requires it, then I think the rule is a disciplinary rule. So
yeah, and I think
guess I'm a little concerned about I'm a little concerned about postulating a duty under 1.1 to prepare a succession plan. Does that mean that if you don't prepare a succession plan, conceivably you could be disciplined for not doing so? So I realize the rules of professional conduct don't circumscribe the whole world of legal ethics, but to me this smacks more of a sort of a standard of care or a best practices concern, and not so much a black letter law of ethics. And maybe it's my my discipline background. It makes me a little skeptical about finding a duty in Rule 1.1 to do this.
Yeah, and I think we just discussed that we're not going to present it that way, and that we're going to say that there may be an obligation, and it wouldn't probably be under 1.1, but 1.3, and talking about formulating it in the context of like the comment 5s that some jurisdictions have adopted, where there may be a duty. So I think the fact that we're saying there may be a duty, would give us an opportunity to discuss this. I don't think, as we said, that this would be something where people would be disciplined for, because we're not saying you absolutely have a duty, and if you don't, you're going to be disciplined. That's not really the approach I think anyone would feel comfortable with. So I think it maybe is just about trying to see how we can flesh it out and see if people are comfortable with it in sort of the qualified approach or not.
How many solos do we think actually have the succession plan or this surrogacy agreement in place? And I would bet it's under 10%. Well under, probably.
I think that's well under 10%.
Yeah.
Is my guess.
But I mean, there's different elements that, we can identify that, I think part of it is just also like identifying some of these issues that people can think about. I mean, whether you have a surrogate attorney, that's one approach, but like there are some basic things like making sure that you're not the only person that can, has access to your IELTS account, for example, or that someone knows the passwords and can get access to client files. And I think those are certain things too that like there could be a whole list of things that can be identified that would be helpful to have, but not saying you have to have one or the other, right? Like, or if you don't have all 10 of these things, then you're, then that's problematic. I think helpful to identify the ways in which if you didn't have that particular, practice in place, that it could be prejudicial to the rights of your client. And it could be the $2 million case, or it could be like a custody hearing where you don't show up and it has catastrophic consequences for a client, or, immigration. I mean, we can come up with things that are less about money and more about the rights of a person that are, forever changed and implicated. But I don't necessarily, maybe we don't go that particular fact pattern route anyway and just make it more general.
I like the idea of the statute. The statute of limitations, you can't, if you blow it, you blow it.
Yeah.
Right, the recourse is on.
Yeah, okay.
Opposed to.
Okay. Well, I mean, it seems to me if you guys agree that it's worth sort of pursuing on this level, and we can, obviously we want to make sure everyone's comfortable with the way we're framing the fact that someone may have a duty and kind of address these issues if people are comfortable with that. And then a question I think is if anyone wants to join this subcommittee with me.
I will.
Okay, thank you.
There's I don't think we should worry too much. This is very much in people's interests. So we want to get it out there. We don't need to, I'm just reading this ALPS. Succession planning really isn't optional, particularly for souls.
Yeah.
And it goes on and says, basically what you're doing if you don't have a succession plan is you're leaving your spouse.
Yeah.
Right? To clean up the mess. And listen to this. And making matters worse, there's no insurance in place to cover the fallout because no one knew they had to timely contact the malpractice carrier in order to purchase an entail once the attorney passed. So your wife.
Send this link. He's looking at an article online. It looks like.
Oh, okay.
So send
So
it.
I'm looking. It's an insurance. A bunch of insurance carriers writing this.
Yeah.
And they're basically saying we wouldn't be on the hook. Your family is going to be subject to a malpractice claim that they can't understand and can't defend against, right? So we're
What's the
service by putting it out there.
Yeah.
No, it's not that. Yeah, that'll just have to be in the.
I'm not saying we put that in. I'm just
By
saying to my mind, it eases my concern.
Not that it's an ethical duty, but.
I'm persuaded. You got me.
Yeah.
We got to tie it.
Yeah.
Okay, well, we'll work on that. I think Amber and Justin said they would join the committee with me. Mimi, did you get that?
Yeah.
Okay, perfect. All right.
Great.
I'm happy to take the lead on fleshing this out further, and then I'll,
Okay. We're covering an amazing amount of ground, and we're now at the home stretch. And what we've got left is the opinion on costs. Brandon, do you want to say a brief word about that before we discuss it?
Actually, I don't feel qualified because this is really Ken's excellent work.
Right.
So I don't have much to add. I apologize.
Well, I think we could reasonably take the view that we could postpone this and come to it when Ken is here. I have some questions about the way the analysis is framed, but I'm not sure that but I want to take guidance from the group. How do people feel? If they have things they want to talk about?
I'd like to have Ken's input on the discussion. I read it and I thought it was quite good, and I see where I think it fills some gaps I've seen that would be good to be filled, but I think it's probably best if we wait till Ken is available.
That's my instinct too.
Yeah, me too.
All right. If that's the case,
Class dismissed.
we're done. No more teachers, no more books. All right. Thank you very much, David and Brandon.
Thank you.
And
Thank you very much.
Thanks.
You bet. All right.
Guys.
Take care.
I have one more of my documents.
I probably
Go
do.
through here.
Please, let's look.
Brandon Krieger and David Carr.
Has left the conference.